Thank you very much. My name is Patsy Bryson. I'm the chair of the Town of Hilton Head Island Board of Zoning Appeals, and I call our meeting to order, the meeting of Monday, December 14, 2020 at 2:31 p.m. Ms. Haley, are we in compliance with FOIA?
Yes, ma'am, we are.
Thank you very much. Ms. Haley, will you call the roll, please?
Certainly. Mr. Walzak?
Present.
Mr. White? Mr. White? If you'll unmute on your end, please. Okay, we'll give him a second to try that out. Ms. Loudermilk?
Present.
Ms. Bryson?
Yes, present.
And Mr. White? Mr. White, do you want to maybe dial in from a phone?
It appears as though Mr. White has left. Let's see if he can rejoin us.
Is that better?
Yes, we can
Yes,
hear you
sir,
now.
Mr. White.
Okay.
Okay, we have our quorum of 4 board members. We also have Dr. Ponder and Mr. Johnson as excused members from today's meeting. And
Thank you, Ms.
Madam Chair, would you
Yes,
like
ma'am.
me to introduce the staff members that are in attendance?
Yes, ma'am, that would be very helpful. Thank you.
Wonderful. Okay, we have Brian Eber in our Stormwater Division joining us today. We also have on the line Nicole Dixon, Development Review Administrator, Tyler Newman, Senior Planner, Missy Lewick, Senior Planner, and Curtis Coltrane, our Town Attorney.
Thank you, Ms. Haley. The next item on our agenda is the welcome. So we welcome all who are participating in today's meeting. I'm going to now explain the procedures that the board will follow. Today we have 2 types of matters. One is a request for a variance, and the other matter is a request for reconsideration by the board. With regard to all matters before the Board of Zoning Appeals, our goal and our responsibility is to provide a fair and impartial hearing for the applicants and for the staff, as well as for public comments. In order to do that, we follow procedural and substantive due process. By doing that, we follow the requirements of the town's land management ordinance, the statutes, and the Board of Zoning Appeals rules of procedure. With regard to variances, the substantive and the procedural requirements are set forth in the LMO in subsection 16-2-103S, and also in the rules of procedure of the Board of Zoning Appeals found in Article 7. The procedure for variances and the rules of procedure of the Board of Zoning Appeals are as follows. Staff shall have a maximum of 20 minutes to present the facts and applicable legal principles that the staff believes support the position of staff with respect to the application for a variance. During the presentation by staff, members of the Board of Zoning Appeals may ask such questions as they deem appropriate. At the discretion of the chair, staff's time may be extended if the staff is unable to complete the presentation due to questioning from the Board of Zoning Appeals. The applicant shall then have a maximum of 20 minutes to present the facts and applicable legal principles that the applicant believes supports the application for a variance. During the presentation by the applicant, members of the Board of Zoning Appeals may ask such questions as they deem appropriate. At the discretion of the chair, the applicant's time may be extended if the applicant is unable to complete the presentation due to questioning from the Board of Zoning Appeals. The staff shall then have a maximum of 5 minutes to present any desired rebuttal. Following the presentations, the Board of Zoning Appeals may ask such additional questions of the applicant or staff as the members of the Board of Zoning Appeals deem appropriate. The chair will then call on interested persons and request that they come to the podium, but Ms. Haley will explain the process for public comment shortly. With regard to motions for reconsideration, found in Article 11 of the Board's Rules of Procedure, Section 1, Motion for Reconsideration. Any party aggrieved by a decision of the Board, if they desire to do so, is required to file any petition for reconsideration by delivering the same to the administrator within 10 days from the date of hearing. Delivered as referenced in this section means actual delivery. The petition for reconsideration shall be in writing and shall state with particularity the points alleged to have been overlooked or misinterpreted by the Board. The petition for reconsideration shall be presented to the Board at the next regular scheduled meeting following the filing of the petition for reconsideration after compliance with public notice requirements for a Board public meeting per the LMO. A motion to grant the petition for reconsideration may only be made by a member of the Board who voted on the prevailing side in the original vote. The effect of the granting of a motion for reconsideration shall be that the Board will review the entire matter as if no previous vote had been taken. A motion to deny the petition for reconsideration may be made by any member of the Board. The effect of a vote denying a petition for reconsideration is that the vote shall be considered to be the Board's final action on the matter. A notice of action shall be delivered to the applicant following such vote. The next item on the agenda is approval of the agenda. Does staff have any changes to the agenda?
No, ma'am, we do not.
May I have a motion to approve the agenda?
So move.
Charlie here, I'll second.
A motion made by Ms. Loudermilk and second by Mr. Waldsack. Ms. Haley, will you call the roll? And at the time the roll is called, if any board member has any changes to the agenda, please state so. Ms. Haley, please call the roll.
Mr. Walczak,
In favor of the motion.
Mr. White,
Approved for the motion.
Ms. Loudermilk,
For the motion.
Ms. Bryson.
For the motion. So the agenda is approved. The next item on the agenda is approval of the minutes of the November 23, 2020 regular meeting. May I have a motion to approve the minutes of the November 23, 2020 meeting?
So moved.
And that, I think, was that you, Mr. White?
It was.
Thank
Charlie
you,
will
sir.
second it.
And Mr. Waldsack seconded. At this time, Ms. Haley will call the roll. If there are any board members who have changes to the minutes, please state so when your name is called by Ms. Haley. Ms. Haley, please call the roll.
Mr. Walczak,
For the motion.
Mr. White,
For the motion.
Ms. Loudermilk,
For the motion.
Ms. Bryson.
For the motion. The minutes are unanimously approved. Ms. Haley, will you address the citizen comments at this time?
Certainly, Madam Chair. Public comments concerning agenda items were to be submitted electronically via the Open Town Hall portal. All comments were provided to the board for review and made part of the official record. Citizens were also provided the option to give public comment during the meeting by phone. There were no requests to give public comment by phone.
Thank you, ma'am. Without objection, the public comments on the portal will be made a part of today's record. Is there any objection? Thank you. The next item on the agenda is a request for postponement approved by the BZA chair. The appeal request APL-002275-2020, a request for appeal from Leslie Ford on behalf of Cedar Woods Property Owners Association. The appellant is appealing staff's denial of a tree removal request in the open space behind 16 Song Sparrow Lane, which was sent to the applicant on November 9, 2020. Pursuant to the rules of procedure of the Board of Zoning Appeals, I have approved this postponement. It's my understanding that that will be scheduled for our regular meeting on January 25, 2021. The next item on the agenda is new business, and I'm now opening the public hearing for a variance request from Bruce Gray. Bruce Gray. That is variance number 001977-2020 for a variance from subsection 15-5-102 setback standards in the LMO, from subsection 16-5-103 buffer standards in the LMO, and subsection 16-5-113 fence and wall standards in the LMO to allow an existing patio and fence to remain in the adjacent use setback and buffer. The property address is 11 Sandcastle Court with a parcel number of R511 009 000 1108 quadruple O. At this time, there will be a staff presentation with a maximum of 20 minutes by Ms. Lewick, Senior Planner. Ms. Lewick, you may proceed.
My name is Missy Lewick, Senior Planner for the record. Again, as mentioned, this is a presentation for 11 Sandcastle Court for a variance, and the variance number again is VAR-001977-2020. Our air keyboard isn't working. This request is from Mr. Bruce Gray for a variance from section 15.5.102 setback standards, 16.5.103 buffer standards, and 16.5.113 fence and wall standards to allow an existing patio and fence to remain in the adjacent use setback and buffer. This property is located in the Sandcastles by the Sea subdivision off Follyfield Road. The subdivision was approved in 2007. The subdivision is surrounded by the Hilton Head Beach and Tennis Resort, which is multifamily residential to the east, single-family residential to the south, town-owned property and single-family residential to the north, and Adventure Cove and Carrabba's Restaurant and an office building to the west. Here is a parcel view of the subdivision, and here is the subject property, which is highlighted in an aerial view of the subdivision. It is number 11 on this image. And here's the subject property again in our street view or parcel view. And next slide. Okay. So this is the subdivision plat. We'll zoom in a future slide, but the Sandcastles by the Sea subdivision was approved with a 20-foot adjacent use setback and buffer around the perimeter of the subdivision. There was a 25-foot adjacent use buffer approved in the western subdivision perimeter, which is shown in the subdivision plat. And here is a zoomed-in version of the same subdivision plat. 11 Sandcastle is Lot 2 on this plat, which is circled in red, and the 20-foot setback and buffer is highlighted on this screen. The purpose of the adjacent use buffer standards is to spatially separate development from adjacent development with aesthetically pleasing natural or landscape buffers. Such buffers are intended to help mitigate potential negative effects between adjacent uses and provide space for landscaping that can help improve air and water quality and be used to reduce stormwater runoff. The purpose of the adjacent use setback standards is to provide separation between structures and property lines. Such separation is intended to maintain and protect the town's island character and facilitate adequate air circulation and light between structures and adjacent developments. Buffers and setback areas frequently overlap, but the standards that apply to these areas are different. For example, uncovered patios are allowed to encroach up to 5 feet in setbacks, but patios are not allowed in buffers, which are meant to be landscaped or naturally vegetated. This slide shows a type A buffer from the LMO. And at the time the subdivision was approved, there was not flexibility in buffer options. With the 2014 LMO rewrite, the buffer standards were made more flexible, as depicted in this slide. For the portion of the subdivision adjacent to multifamily, which is adjacent to 11 Sandcastle, the subdivision development could now require either a Type A Option 1 20-foot less densely vegetated buffer or a Type A Option 2 10-foot more densely vegetated buffer for a single-family residential use adjacent to a multifamily residential use. A 20-foot setback is still required along the perimeter of a single-family subdivision adjacent to a multifamily residential use. So if we were reviewing this subdivision today, this portion is where we could now allow potentially an Option 2 Type A buffer adjacent to the multifamily use or beach and tennis resort. However, through the course of the various Sandcastle variances, staff has been informed that private covenants exist that prohibit disturbance of the 20-foot buffer along the lagoon in between Sandcastles by the Sea subdivision and the Hilton Head Beach and Tennis Resort development. The private covenants prohibit the developer or property owner from seeking the 10-foot buffer option adjacent to the Hilton Head Beach and Tennis Resort development. Here's some of the history as to where we have been with this particular subdivision and the various complaints of setback and buffers. In July of 2019, staff received several complaints about property owners removing vegetation in the buffers and making improvements such as patios within the buffer. Upon a site visit, staff found several violations in the area in which we received complaints about. Violation letters were sent to the property owners notifying them of the violation and providing a deadline to remove the encroachments or apply for a variance. A representative of the property owners contacted staff after receiving the violation letters and asked if the deadline to remove the encroachments could be extended to November 2019, as the majority of the homes are vacation rentals and it was the middle of the summer season. Staff felt this was reasonable and extended the deadline. In early fall of 2019, the representatives of the property owners met with staff to discuss their options. One of their requests was to reduce the buffer to the 10-foot buffer option. Staff informed them that to utilize the reduced buffer option, the entire subdivision plat would need to be revised and recorded. Town staff had been working with the representatives to pursue a buffer reduction request for the entire subdivision, but it was determined by the representative to be too costly to do so, and they didn't think they could get 100% owner's consent. Staff was informed in spring of 2020 that there were several other properties in this subdivision that had encroachments in the buffer. Staff decided to do a site visit to all the properties in the subdivision and compiled a list of the violations. In August of 2020, a second violation letter was issued to property owners with a deadline to remove the encroachments and restore the buffers back to a vegetated area by October 1, 2020. The property owners were informed that if they did not adhere to the deadline, the town would place a hold on their parcel, making it so no further building permits could be issued until the violation had been corrected. The property owners were also informed that they had the option to apply for a variance if they wished to keep the encroachments. Here is the particular variance requested today. Here's the 11 Sandcastle as-built. And this property was constructed in 2018 and purchased by the current owner in August of 2020. This subject property is currently developed with a 3-story single-family residence with 3,314 heated square feet, 1,137 unheated square feet with 5 bedrooms, 4 bathrooms, a garage, and a pool. This slide is a drawing that was prepared by the applicant that shows the approximate area of the encroachment, which their patio area is what they circled in blue. And after the home was constructed and the certificate of occupancy was issued, the owner had an approximate 24-foot 6-inch by 12-foot 1-inch field measured paver patio constructed in the rear of the property that extends from the pool area into the rear adjacent use setback and buffer. The patio encroachment is approximately 12-foot 1-inch, again field measured, in the adjacent use setback and buffer, although it tapers to a lesser encroachment length due to the parcel shape. There is a fence also located in the adjacent setback and buffer and is approximately 13-foot 4 inches field measured at its greatest distance into the adjacent use setback and buffer, although the encroachment length again tapers due to the parcel shape. LMO section 16.5.102E allows for uncovered porches, stoops, decks, patios, or terraces to extend up to 5 feet into any setback. And while a patio can encroach up to 5 feet into a setback, it cannot encroach into a buffer. Portions of the existing patio exceeds the allowable setback encroachment. The applicant is seeking a 12-foot encroachment to allow the existing paver patio and fence to remain in the rear adjacent use setback and buffer. However, staff field measured the encroachment at its greatest length to be 13-foot 4 inches into the setback and buffer. Here are some of the images of the patio and the existing buffer vegetation. And here are some more images of 11 Sandcastle and their encroachments. At this time, I'm going to go through the 4 criteria. The first variance criteria is there are extraordinary and exceptional conditions pertaining to the particular piece of property. Sandcastles by the Sea is a small lot single-family subdivision that consists of 83 lots. Most of the lots within the subdivision range from 0.06 to 0.13 acres, with the majority of the lots around 0.07 acres. The majority of the lots in the subdivision were platted with a 20-foot rear setback and buffer. The subject property is mostly rectangular in shape, as are the majority of the lots in the subdivision. This subject lot is 0.08 acres in size, and the subject property does not contain any unique site features that prohibit development on the lot. And staff concludes that this application does not meet this criteria, as the subject property is average in shape and size for the subdivision and does not contain any extraordinary or exceptional conditions that prohibit development on the lot. Criteria number 2, these conditions do not generally apply to other properties in the vicinity. There are no extraordinary or exceptional conditions that pertain to this particular property. The majority of the lots in the Sandcastle by the Sea subdivision are nearly identical in size and shape. A 20-foot adjacent use setback and buffer is applied to all of the properties located on the perimeter of the subdivision, except for those on the western perimeter, which have a 20-foot adjacent use buffer. And the conditions that apply to the subject property also apply to other properties in the vicinity. The staff concludes that the application does not meet this criteria, as there are no extraordinary or exceptional conditions that apply to the subject property that does not also generally apply to other properties in the vicinity. Variance criteria number 3, because of these conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. There are no extraordinary and exceptional conditions that pertain to this property. Again, the Sandcastle by the Sea subdivision plat was approved with the 20-foot adjacent use setback and buffer in the rear of the property. The Sandcastle by the Sea subdivision plat has a note that reads, "The only activities permitted in the exterior subdivision buffer as labeled on this plan shall be those listed in permitted activity in other buffer areas as per the LMO." LMO section 16.5.103J, development within required buffers, does not list the patio or retaining wall as permitted activities within a required buffer. And the subject property is currently developed with a 3-story family residence with 3,313 heated square feet, a 5-bedroom, 4-bathroom home with a garage and a swimming pool. Staff concludes that this application does not meet the criteria, as there are no extraordinary or exceptional conditions that apply to the subject property that would prohibit or unreasonably restrict the utilization of the property. Variance criteria number 4, the authorization of the variance will not be of substantial detriment to the adjacent property or the public good, and the character of the zoning district where the property is located will not be harmed by the granting of the variance. At the time that the staff report was published, we had not received letters of opposition to the request. We have since received a letter of opposition that was in the portal comments. The purpose of the adjacent use buffer standards is to spatially separate development from adjacent development with aesthetically pleasing natural or landscape buffers. Such buffers are intended to help mitigate potential negative effects between adjacent uses and provide space for landscaping that can help improve air and water quality and be used to reduce stormwater runoff. The purpose of the adjacent use setback standards is to provide separation between structures and property lines. Such separation is intended to maintain and protect the town's island character and facilitate adequate air circulation and light between structures and adjacent developments. The applicant is requesting to keep the existing paver patio and fence, which encroaches in the rear setback and buffer. And the use of the hardscape in the buffer area is a modification to the civil engineer stormwater runoff calculations for the Sandcastle by the Sea subdivision. The area that's considered buffers typically produces very little stormwater runoff due to the existing natural understory flora. And when this area is disturbed and modified with patio pavers, gravel, and sand, it changes the amount of stormwater runoff that was expected to be from a natural vegetative buffer. And staff has also been informed that private covenants exist that prohibit disturbance of the 20-foot buffer along the lagoon in between the Sandcastle by the Sea subdivision and the Hilton Head Beach and Tennis Resort development. The private covenants prohibit the developer or property owner from seeking the 10-foot buffer option adjacent to the Hilton Head Beach and Tennis Resort development. Staff concludes that the application does not meet the criteria because the variance will be of substantial detriment to the adjacent properties, because the purpose of the setback and buffer requirements is to provide visual and spatial separation between developments and mitigate the negative effects between adjacent uses. Also, due to the number of buffer encroachments and the impacts to the stormwater system, town engineering staff recommends that this practice not be allowed to continue. And it is staff's recommendation that the BZA deny the applications based on the findings of fact and conclusions of law contained in the staff reports, and that none of the 4 variance criteria are met. Therefore, again, staff is recommending denial. That concludes my presentation. I want to make the staff report and this presentation part of the record today. If there are any questions from the board members, I can entertain them at this time. Thank you.
Thank you, Ms. Lewick. Are there any objections to the staff presentation being a part of the record?
No.
Hearing none, the staff presentation will be a part of the record. Now it's time for board questions. Mr. Walczak, do you have any questions of staff? Mr. Walczak, you need to unmute.
No, not at this time. Thank you.
Thank you, sir. Mr. White, any questions of you?
No, I thought it was a very thorough presentation.
Ms. Loudermilk, any questions from you?
I do not.
And that leaves the chair, and I have no questions at this time. Now we turn to the presentation by the applicant, Bruce Gray. Mr. Gray, you have 20 minutes, and our administrative secretary, Ms. Haley, has a timer and will alert us when the time has expired, unless you have concluded before then. So, Mr. Gray, go ahead and proceed with your presentation.
Good afternoon. Can you hear me?
Yes, sir.
Okay. And can you see my screen?
Yes, sir.
Okay, great. Thank you for making the time today. And I do not believe I'll take the full 20 minutes. So I think Missy did a good job locating the lot for everybody's awareness. So that's just where the lot is. There is the lot to the left of me is open, it's unbuilt, and the lot to the right has a house on it very similar to mine. Quick, this is a before picture, not of my exact lot, but they're all the same in terms of what was there before I actually took ownership. So the CO was issued by the town with grass in the back on this area. The only vegetation was this sod. It was dying. It was on plastic mesh. There was no, the area in question had no vertical vegetation. And what I mean by that, there was no trees, shrubs, bushes whatsoever in the area in question. This is the after picture with the, as Missy showed, there's a black fence and there's a paver patio. So I'm going to go through the 4 criteria. You're intimately familiar with these criteria. So criteria 1, the extraordinary and exceptional conditions for this particular piece of property. So in the town's findings of facts, I want to have one clarification. The rear lot line is angled. It's angled along the lagoon. So the right side is shorter and the left side is longer. And that the difference is 11.54 feet along the left property line. And why that is important is because I'm not in violation on the left, but I am in violation on the right in terms of the buffer. So another point I want to make is the slope of the property. The top picture shows what is left of the ground level slope after I had leveled for the patio. And the bottom picture shows the elevation drop from the top survey marker on the upper level to the lower survey marker down by the lagoon, which is roughly a 3-foot drop. And again, this will be relevant during the rest of my presentation. So what makes this lot extraordinary and exceptional? It's extremely small, which makes them unique. You have seen this in the prior presentations for people coming before you relative to Sandcastle. Every lot in the vicinity is at least 50% larger than the Sandcastle lots. The setbacks and buffers cut off 50% of the lot. And here's one of my biggest concerns is the safety aspect. So the original slope of the lot when I took ownership had a 5 to 6 foot drop from the edge of the pool to the lagoon with a roughly 3-foot drop from the ground level over a railroad tie wall into the lagoon. So you can imagine the safety with small children getting out of a pool, rolling down this hill into the lagoon, chasing a ball, falling into the lagoon. It's a big, big safety concern. There's alligators in the lagoon. The fence is a very non-obtrusive barrier to keep alligators out of the swimming pool and out of the other livable space. Underneath the back side of the house is the pool, and right from there you can go right inside. As you can see on the drawing, which Missy also used, there's roughly a 7-foot. I corrected it. Thank you, Missy, for the on-site measurements, which probably more accurate than mine. On the back right, there'd be roughly a 7-foot buffer on the right side, but that'll be a full 20-foot buffer on the left side. So the vegetation buffer would increase from roughly 7 feet to roughly 20 feet as the property deepens along the lot, the property line. There's an additional 100 to 200 feet of water buffering this property with the Hilton Head Beach and Tennis. Without this patio, the rear yard is essentially useless with the safety concerns and the exposure. criteria number 2, ties to the properties in the vicinity. So the town's findings of facts, you've seen this before. Per the town's own survey, the vicinity is far broader than the Sandcastles by the sea. This is not my terminology. This is the terminology on the town survey. You can see it I circled it in the top left in red. So if you look at the legal terminology here, you have the vicinity on the left and the site as marked on this map is on the right. So the site is Sandcastle. The vicinity is far bigger than Sandcastle. So when you take that context, the vicinity is the entire area. It's far bigger than what you see in the Sandcastle subdivision. And every lot in this area is 50%, at least 50% bigger than what we have in Sandcastle. So again, this same extraordinary and exceptional criteria apply here. So when you look at it, the town's conclusion of law that these conditions don't generally apply to other properties in the vicinity, that's entirely incorrect. With every lot being in the vicinity being at least 50% bigger, this makes this unique. It is not the same. The setback and buffers, again, cut off 50% of the lot. You have the safety concern and the alligators again. So it's entirely different. Criteria 3, unreasonably restrict the utilization of the property. So the town's conclusion of law, again, is not true. The criteria that do generally apply to other properties in the vicinity, per the vicinity, it's far bigger than what we have in just purely the Sandcastle subdivision. The lots are 50% smaller, extremely small, cut off the buffers, the safety concerns. The utilization of property is restricted. Outdoor space is expected. These are your own words from the last hearing. When you buy a piece of property, you're expected to be able to use it. In this case, if I'm not able to keep this patio and keep it level, I'm not able to use it. It's rolling right into the lagoon. The 4th criteria, set substantial detriment to the adjacent property or public good. The town's findings of fact, no natural or landscape buffers have been altered. I want to repeat that. No natural or landscape buffers have been altered. None. There was no structures in the setbacks impeding any air circulation or light. Yes, I am here requesting a variance. The stormwater runoff calculation does not apply. There was a over 5 to 6 foot slope from the edge of my pool into the lagoon. We all understand gravity. Where was that water going? It was going downhill into the lagoon. What we have right now is it's likely distributed better out to any of the existing natural vegetation that can absorb it. But what you have originally was basically a slope, a runway right into the lagoon with the water. So I have in no way impeded any stormwater. There was never any natural vegetative buffer that was removed. There was no existing natural flora that was disturbed. Nobody has been harmed. And my neighbor to the right at 13 Sandcastle was seeking the very similar variance, same patio situation. So what I'm here asking for is to approve it or approve it with conditions. Just how we got here. Apologies for not seeking a variance to begin with. I was told I didn't need one. I saw the neighbors. Most neighbors had a patio. Assumed it was true. I could just put it in. Based on my presentation, it's clear all 4 criteria have been met. I'm offering to plant as much vegetation plants as the town deems appropriate. And my cost, I'll plant them. Whatever you feel is the best plantings, I'll do it. I'm looking for a solution here where I can safely use my backyard and don't truly infringe on anyone else's enjoyment on their property. No one but my direct neighbors can see my backyard. One has the exact same situation with the patio, and there's no issue. And the other people are on the other side of the lagoon in Hilton Head Beach and Tennis. They not in any way can see my property. There's so much vegetation, 10 to 15 feet tall. There's no visibility from the other side of the lagoon into my backyard. My understanding is that a fence is okay along the property line, but it just isn't practical because my property line is in the lagoon. So it is practical where it is currently placed. My also understanding is that each application has to be considered individually and voted on individually. And I think I've listened to and addressed all the concerns that I've heard in the previous hearings. So with that, thank you for all your time. I appreciate it.
Thank Thank you. Thank you, sir. Thank you, Mr. Gray. This time is opportunity for board members to ask questions. See, Mr. Walczak, do you have any questions?
Yeah, actually, a couple of questions. Did you buy this house already built, or did you have it built for you on the lot?
I had it built for me on the lot.
Well, then the follow-up question would be, why didn't you build it further back away from the lagoon so you could put a patio in?
That was not a choice. The building envelope is predetermined, is my understanding.
All right. The word vicinity, by the way,
Yeah.
is obviously subject to interpretation. In the maps that you've shown, and I'm an engineer. I've dealt with maps and surveys all my life, and a vicinity map is basically there to show where it's located in relationship to the rest of the area. It doesn't necessarily mean that your lot is not compatible with the vicinity, that because it happens to show up in a little inset map on the survey. So I'm just saying, I just wanted to make that clear that it's really subject to interpretation as to what vicinity is.
Well, I'm just on that point. I'm not saying that my lot is not part of the vicinity. I'm saying the vicinity is far larger than the site as defined by the Sandcastles by the Sea subdivision.
Yeah, and I think, and not to go further on this, but I think the town's interpretation is that the vicinity means the Sandcastle subdivision.
I understand that, but when you have a legally signed document, that has legal meaning.
Okay, my questions are over. Thank you.
Yeah.
Thank you, Mr. Walczak. Mr. White, questions from you.
Just one, and it's a kind of a carryover. Mr. Gray, when you purchased the property, did you have knowledge of the setback in the buffer area?
I did not when I purchased it, no.
Okay, thank you.
Thank you, sir. Ms. Loudermilk, questions from you.
Yeah, just a few. Mr. Gray, could you expand or just maybe better define? You said your rear property line is literally in the lagoon. Did I hear that correctly?
That is correct. The neighbors next door have been on the left-hand side, have been getting a survey, and you can actually see the survey marker. It is in the lagoon.
Okay. Roughly, but how far into the lagoon? Are we talking 2 inches or 2 feet?
No, we're talking, I'd say 6 feet plus or minus, easily. And
Okay.
And I could actually bring up the picture again real quick.
Yeah, I'd be interested to see it if you can.
Okay, hold on. Here we go. Okay, so the bottom right-hand picture. Well, start at the top. You see the survey stake over on the left. So that survey stake is the same survey stake that is on the right. And then you can see, I put the red arrow in. There's a slight little orange tape on top of another survey. That is in the water, in the lagoon.
Okay. All right. Okay. I see what you're saying. Another question. You said you were told that you didn't need any variance for the patio.
That is correct.
Who told you that?
The builder.
The builder. The builder of the home or the builder of the patio?
The builder of the home.
Okay.
And, couple that with looking around and seeing all the patios in the neighborhood. 2 + 2, I assumed, is 4.
And you mentioned that you didn't feel you had the leeway, if you will, to position the home closer to the front property line. Do you know how far back are you from the front property line? Can we see that on the?
There might be, so it's right here. Oops. Okay. So it looks like there's, to the front of the house is 25.9 feet, if I'm reading this correctly. But right at street level, right to the left of the driveway is a massive, one of those old oak trees that actually, my understanding is those are sacred and not to be cut down. So there was no way to build the house closer without taking down that tree, because those the tree trunks and branches go over the current house as it sits. So
Okay. All righty. Thank you.
You're welcome.
Those were my questions.
Thank you, ma'am. That leaves questions to me. Following up on Ms. Loudermilk's question about the location of the house, would there not have been another option of building a house, taking into consideration the oak tree so that it would not come so close to the back property line?
By making the house smaller?
Yes, sir.
I'm sure that would have been an option, but with the lot being owned by the builder, and then it was a package deal. There was no consideration for a smaller house.
Okay, so you could not choose a smaller house. You could not choose another plan.
I could.
Okay.
The only options were not the footprint of the house, but what was upstairs, how many bedrooms, how many bathrooms. But the footprint of the house of the choices were all the same.
Did you not make any alterations to the plans?
None.
Okay. I think you had in your presentation part of the as-built. Can you pull back up one of those as-built drawings, part of the survey?
Sure.
Not sure whether you have one that you can enlarge, or maybe you can enlarge that a bit for us.
Does this help? You want to go to the area in question or the whole site?
No, that's fine. Right there is just
Okay.
fine.
Yep.
So if I understood your testimony, that the property line goes into the lagoon.
Correct.
But my question for you is that this shows the property line is approximate edge of the lagoon, not in the lagoon.
Well, I can only tell you that the property stake as put in by the surveyor is in the water.
And that is the surveyor for your neighbor's property and not yours? Did I understand that?
It's for this back left marker, which is, one and the same. One marker would signify the end of mine and the beginning of theirs.
Okay. All right. So is it the same surveyor who prepared this as-built drawing that we're looking at now?
I couldn't say. I don't know.
Okay. All right.
I did look along the property line, and it does, because I was just curious what he was doing, and it does dovetail specifically with, that my property line. So I'm assuming he's putting that stake in the correct place.
So as I understand your testimony, the builder told you did not need a variance to construct the patio. Is that correct?
That is correct.
Was that based upon your inquiry? Can I build a patio, or did the builder offer that to you?
I believe I asked about it looking at the other patios in the neighborhood.
Okay. Did you make any other inquiries, such as to the town, about building a patio within this area?
No, I did not.
So your reliance was solely upon the builder?
At that point in time, yes. Clearly in error.
Did you look at the survey information or the recorded plat to show where the building line is?
I did not, no.
Okay, those are my questions. Any other questions from the board members?
Just one, Ms. Chairman.
Yes, sir.
Mr. Gray, was this purchase, given the fact that the builder was showing a great deal of inflexibility with respect to the size or the location of the building. Was this purchased or sold with the intent of as being a rental property?
I do rent it, but I also spend a good deal of time there and looking to spend more and more as I get closer to retirement.
Mm-hmm. Okay. Thank you.
Any other questions from board members? If not, at this time, an opportunity for staff rebuttal of 5 minutes. Ms. Lewick, any rebuttal from staff?
I don't have anything formally for a rebuttal, but I do wanted to also reiterate, as the applicant has, that the shape of the encroachment area does taper. And so as he explained, that in one corner, they're not in violation of a setback or buffer, but in the other corner, there is a setback and buffer encroachment. So it's like a triangular shaped encroachment area, if that makes sense.
Missy, is it fair to say this curved line from the one corner of my little blue rectangle, which represents the patio, back to the other corner, that is essentially the slice that shows what is okay versus what is not okay? Is that fair?
That's fair.
Okay.
All right. Board members, any questions based on the further information from Ms. Lewick?
Could we see that as built, that last drawing again?
I have it up on the screen. So I think I do.
Yeah,
Is it not sharing?
We're not seeing it.
Okay, sorry. Maybe I came down.
Bear with us one moment. Sometimes the staff has to change out from sharing. Thank you.
Can you see it now?
Yes. Yeah.
Okay.
Just give me a second here.
Sure. Sorry. The blue box represents my patio. The green
Right.
represents the fence, and that little curve going from one corner to the other corner kind of represents the buffer line.
And I'm not sure if this question is for you or for Missy, but the edge of the lagoon, per this drawing, where is the edge of the lagoon?
Do you see on this drawing, it says property line is approximate edge of lagoon, and then there's a little sort of slight arrow. It appears that they're marking it. The setback and buffer does go out in the lagoon. The lagoon isn't necessarily marked on it, but the applicant says that the survey flag is in the water, which you can see there's the survey corners for the rear of the property.
Right.
Further down at 13, there was a survey stake down there when that request was before us, and when I was on site, I could see that there was another survey stake 2 doors down that was also in the lagoon. But I don't know what that stake was. I just saw a stake down there. I don't know. I assume it's a property corner, but I cannot verify that as a fact. So
I'm just trying to make sure I really understand this entire drawing.
Yep.
Madam Chair, this is Nicole Dixon. I would like to ask Brian Ebert to speak. He's on the call, and he can explain how lagoons function and why they tend to rise and drop based on the tides. So I'd like to ask Brian to get on the call, or he's on the call to speak if you are okay with that.
And this is part of the staff rebuttal. Yes, ma'am. Mr. Eber, I understand you're a town staff member. You may proceed.
Madam Chairman, thank you. I am the Stormwater National Pollution Discharge Elimination System Administrator, which is basically water quality and stormwater runoff. Behind Mr. Gray's property is a tidal pond, lagoon. And so as tides come up twice a day, and as they go out twice a day, you will see some fluctuation in the tidal levels, the level of the lagoon behind your house. So you won't, because you're up at the most upstream portion of that tidal influence, you probably won't see a great amount of variance on your property, but you will see sometimes where your property will be inundated with water. and sometimes it won't. Obviously, during heavy rainfalls, you would also lose property back there. And it's probably why they had, there was such a drop off between the edge of the grade and what was the natural grade that was supposed to be there, because it always had flooded and come up onto that person's property prior to development.
Okay, thank you, sir. Board members, any questions of Mr. Eber?
Yeah, I do, based on your last comment, Mr. Eber, and I realize you were not party to the construction, but from what you said there about the grade, it sounds like the builder would have built up the rear of this lot in order to reduce or minimize the flooding. Is that pretty much what I heard? That is likely to have happened?
I don't know if it's so much of the reduce the property from flooding, but the lowest floor needed to be a certain elevation. We're all familiar with hurricanes.
Right.
It was submitted, and to match the existing slope down to the lagoon, he had to place fill, or had to place a wall, or had to place some sort of structure there. Oh, sorry for my cuckoo. Had to place something there to allow that grade difference between what was the finished lower floor and what was the existing lagoon. So
I would just say that it's highly unlikely it was the builder. It may have been the original developer, because those railroad ties, I'll call them, are not fresh. You know, they've been there for what appears to be a very long time.
Okay. This is an appropriate time for board members to ask staff questions based on the staff rebuttal. Mr. White, any other questions from you?
No, I have no other questions.
Mr. Walczak, any questions from you?
No, not at all.
Ms. Loudermilk, any other questions of staff members?
No.
Okay. At this time, I don't have any questions of staff members. Mr. Gray, you have an opportunity for a rebuttal of 5 minutes. Again, Ms. Haley is our timekeeper.
I think I've presented everything that I wanted to present, and thank you for your time.
Okay, thank you, sir. I understand that Mr. Coltrane is available. And at this time, I'm going to ask Ms. Haley about public comment. Are there any other public comments other than what board members were furnished through the town portal?
No, ma'am.
Okay. Mr. Coltrane, as part of those comments on the town portal, the board received a letter from an attorney as general counsel to Hilton Head Beach and Tennis Resort, including 3 residential property regimes: Admirals Row Owners Association, Inc., Ocean Villas Owners Association, Inc., and Tennis Villas Owners Association, and also a commercial component identified as HHB&T Convention Center, Inc. And I would ask Mr. Coltrane if he's had an opportunity to look at that letter, and if and the letter is in opposition and raises some legal issues. Is there anything from that letter that the board should be advised about? Mr. Coltrane.
I have reviewed Mr. LaBruce's letter, who says that he is a representative of the Hilton Head Beach and Tennis regimes. Attached to his letter was a copy of a declaration of covenants, which, if I've still got them up here, is a recorded document that was recorded in, in June, looks like June 17 of 1998, I want to say. The document is not, it's not, there's a, which, oh, excuse me, 1993, which, you know, establishes the existence of a 20-foot buffer along the lagoon that separates Hilton Head Beach and Tennis from the property that is now Sandcastles by the Sea. The document was recorded prior to the subdivision of the property into the Sandcastles by the Sea subdivision, and the text of the covenants deal with that in some fashion. I don't have a copy of the application for the variance in front of me, so I don't know if that application includes a representation by the applicant as to whether or not any covenants affect the property over which the variance is sought that would prohibit what is being sought. It does appear that there is a 20-foot buffer that exists in favor of the Hilton Head Beach and Tennis regimes here. It's there. I don't think it is the duty of the town to enforce the covenants that inure to the benefit of Hilton Head Beach and Tennis, but those are there irrespective of what the town does. So, the covenants say what they say. They do establish a 20-foot buffer along the rear of the lagoon that separates the two properties. And as far as I know, certainly nothing was revealed in Mr. LaBruce's letter that would suggest that those covenants have been changed in any fashion since the day they were recorded in 1993.
Okay. So it's information for the board. We are not necessarily required to consider that as part of our decision making, or are we required to consider that?
It is evidence that is before the board that the board can utilize in a manner it deems appropriate in its examination of this. Again, I'm not sure that there's a statement in the applications that relate to the existence of any covenants that would prohibit this. But again, I mean, I don't think it's the duty of the town to enforce these. Although I think that if the town, I do think the existence of the covenants does create a problem for those properties that are encumbered by the covenants, because they're bound to comply with the covenants again, irrespective of what the town does.
Okay. Let me ask the staff members who have a copy of the application. I think that's part of the record. Can you share that on the screen for Mr. Coltrane?
I don't have it open to share on the screen, but the applicant likely was not aware of the private covenant, and on the application form he checked no to there being any recorded private covenants or restrictions that are contrary to, conflict with, or prohibit the proposed request.
Okay. All right. Does that help out, Mr. Coltrane?
Well, if the representation by the applicant is that there weren't, that appears to have been incorrect.
Okay. Thank you, sir. Board members have any questions of Mr. Coltrane regarding the letter from Mr. LaBruce on behalf of Hilton Head Beach and Tennis Resort? Any questions from any board members? Okay, if not, I will close the public hearing and we'll move to discussion by the board. Mr. Walczak, your turn in rotation to have any discussion about this matter.
Well, I would like to kind of discuss this matter along with all the others, but that's probably not appropriate at this time. So maybe I should hold off until that time comes.
Well, now's the time for the board to have discussion. So we can go ahead and have that. If you want to defer to another board member, that's fine.
No, that's okay. It's just, obviously, here's what I'm getting at. Obviously, this is not the only applicant. There's his next door neighbor, and there's all the ones on the other side. I mean, there's got to be 8 or 10 situations here or more that even haven't come before us yet. And we talked in the past about possibly refiling the plat to accommodate a different buffer, which would, I guess, have to be approved by the town council. It seems to me that would be one way to try to solve this conundrum, if you will. So I asked Mr. Coltrane, help me out here. Is there a way to somehow do something like that?
Well, as we've discussed before, replatting the subdivision requires everyone in the subdivision to agree to it. And, again, with respect to the owners who have properties along the boundary between Hilton Head Beach and Tennis and this subdivision, the town can change, under the circumstance you've described. The town might change the setback and buffer that the town imposes, but that's not going to have any impact on what the declaration of covenants that favor Hilton Head Beach and Tennis say. That can only be done through the agreement of, the Hilton Head Beach and Tennis folks.
Mr. Walczak, other thoughts or questions? Mr. Walczak, we lost the video, but I still... Are you still there, Mr. Walczak? Uh-oh.
Now.
Oh, there he is.
Yeah, there was some network issues coming up here on my screen. I don't know what it was.
Sure. Go ahead.
What I was getting at is, how can, let's say, covenants from my property affect a neighbor? I don't understand how that's even, legal. I mean, covenants for your own property is one thing. I don't quite understand that, I guess. But then again, I'm not a lawyer.
Well, in this case, the then owner of the property that is now Sandcastles by the Sea agreed to it.
So there would be no chance that Hilton Head Beach and Tennis would reconsider?
Well, I can't speak for them. I mean, that would be a question that would have to be directed to Hilton Head Beach and Tennis.
Yeah, so that's what I'm suggesting, that this neighborhood get together perhaps and look into the other possibilities rather than trying to, we got almost a dozen variance requests here. And if it's a matter of switching a line a few feet, a buffer line a few feet, to accommodate it, it seems like the way to go in order to, not have to rip out all these patios. So I don't know. That's just one course of action I think maybe the applicants should consider with all of his, and join together with the rest of them. Again, I'm just discussing this openly as a means of trying to solve it.
Sure. Okay. All right. Let's move on to Mr. White. Any thoughts or discussion, Mr. White?
Yeah, I tend to agree with Charlie. It seems cumbersome to be looking at this issue in the microcosm with respect to individual lots. There are three? There are 8, I believe, that are seeking this variance, and God only knows how many more. The fact is that the cleanest way and perhaps the most appropriate way is to seek out a replatting of the property, at which time they can join with Hilton Head Beach and Tennis and get this thing cleaned up once and for all.
Okay. Ms. Loudermilk.
I think as with prior applications, I am very empathetic to the challenges here that seem to have been created over the history of the builder and the developer, and those being different entities at different times, who either entered into agreements and or made what might have been misrepresentations in order to have this property appear developable in a marketable manner. Having said that, I don't think the problems with the history create a reason for us to grant variances. I totally agree with the comments of Mr. White and Mr. Walzak of the optimum is to explore other solutions, be it with Hilton Head Beach and Tennis and or the property owners within the association, such that there might be some possible replatting. I positively think these are challenged properties, but again, I'm not hearing any legal reason to approve variances. I think this is one of the most challenging cases that have come before us.
Thank you, ma'am. That leaves it to me as chair to comment. I'm greatly troubled by the large house being put on such a small lot, that someone would have had knowledge from having looked at the lot and looked at the subdivision to see that it was a small lot and close to a lagoon. If one were there at different times of the tide, based on what Mr. Eber is saying, that you would see the water come and go from that edge of the lagoon. I'm just very troubled with trying to put so much of a house and then to extend it through a patio into such a small lot. While I'm empathetic to the property owners, as others have indicated, we're limited with regard to what we can do. Our sole consideration is whether or not a variance should be approved or denied with regard to this particular lot. That is our sole question, notwithstanding that we have other instances within this subdivision where there have been applications for variances and maybe others. But we have to decide on the basis of this lot and on the factual situation on the record before us and on the findings that must be made. So I am not inclined to approve this variance. With that said, is there a motion from a board member to either approve or deny the variance?
Yes, I can do that if you'd like. I would like to move that we disapprove the application based on those findings and facts and conclusions of law that were found in the staff determination.
Okay, is there a second?
And I second that.
That's Mr. White made the second. Ms. Haley, will you please call the roll on the motion?
Certainly. Mr. Walzak?
For the motion.
Mr. White?
For the motion.
Ms. Loudermilk?
For the motion.
Ms. Bryson?
For the motion.
Motion carries unanimously, 4-0.
Thank you, ma'am. Thank you, Mr. Gray, for your presentation. There will be a notice of action signed by the maker and the second of the motion and by the chair. And the staff will provide that to you along with your right to appeal the decision of the BZA. So we'll move on to the next item on the agenda. And that is, we have several hearings on motions to reconsider previous action taken by the board. If you'll bear with me to get to the right page. There are 6 motions to reconsider. I had previously described the procedure in the Board of Zoning Appeals Rules of Procedure. There are different, there's a few different considerations for these as to who could make a motion to reconsider. The motion must be made by someone on the prevailing side. Of those 6 motions to reconsider, the one that is E, motion to reconsider variance 00-1935-2020. Only Ms. Bryson or Ms. Loudermilk can move to reconsider that one based upon those who are on the prevailing side at that time. The other ones, Ms. Loudermilk, Mr. Walczak, Mr. White, or Ms. Bryson could make a motion to reconsider. So when we get to those individually, we'll do that again, but I wanted to start out with that clarification about who could make a motion. If the motion for reconsideration is granted, then the hearing would be held at our January 25, 2021 meeting. We will be looking at how many we might have in January to determine whether or not we need to have a second meeting. So we'll hold that in abeyance for now. If there is a new hearing, if there is a reconsideration, it will be as though no previous vote had been taken on the application. If there is a motion to deny the motion for reconsideration, it can be made by any member of the board. And the effect of a vote to deny a motion for reconsideration is that the vote shall be considered the board's final action on the matter. That is a procedure that we will follow, and we will consider these individually, beginning with the presentation by the applicant. The first one is subsection B, the hearing on the motion to reconsider variance 00-1976-2020. The presentation is by Alexander Barnum on behalf of Joseph DeVito, requesting the board to reconsider our decision to deny the requested variance for 117 Sandcastle Court. Ms. Barnum will have 20 minutes to make the presentation. Again, Ms. Haley will serve as the timekeeper. Ms. Barnum, are you with us on the call?
I am. I don't have video right now, but I do have audio.
Okay, then you may proceed.
Okay, so can I just first start by saying, after having listened to the previous stuff and the fact that, you did ask for public comment, and I really can't comment when I'm in the meeting, but I know that all the members of the board are more than likely long-term residents of Hilton Head, and I'm actually very surprised that it seems as though the vast majority of the members of the board don't really seem to understand how it works with these builders. But I am not only a member of Hilton Head and Bluffton since 1994, but I am also a real estate agent who has worked in general brokerage as well as new construction. I'm intimately aware of Village Park Homes. The questions that you stated to the other homeowners in regards to whether or not they were able to choose, when you're working with a major builder like Village Park Homes or D.R. Horton, they have a set of already engineered home plans that you cannot change, like to the point where they won't even let you put in an island in your kitchen. So I just want to make it aware that none of these homeowners had an opportunity to move their house forward or backward, make it skinnier, wider, whatever the case is. They had set floor plans to choose from, and that was it. The builder wasn't making any exceptions or anything along those lines.
Ms. Barnum, I'm sorry to interrupt you, but you will need to stay within the confines of your petition for reconsideration on behalf of Mr. DeVito.
Okay, so the home that I'm representing is on the northern boundary of Sandcastles. And due to the extraordinary and exceptional site conditions that existed on that lot, being only 0.07 acres, the northern boundary subdivision prior to the issuance of the certificate of occupancy, the home should not have been held hostage to the same rubber stamped findings of fact or conclusions of law applied to homes at the other outside and inside perimeter boundaries of the subdivision. At the conclusion of the November 23rd, 2020 BZA meeting, petitions for reconsideration were granted and approved by the quorum for my adjacent northern boundary subdivision neighbors at 119 and 123. So I think everybody that is here today was also here in the November 23rd meeting, or at least most of them. I know the doctor is missing, but at that time, and again already in this meeting, there has been somebody that has suggested that these homes should all be considered as almost as one, especially along that northern boundary line. The owners of 119 and 123 have identical situations to the gentleman that I am currently representing. The lots on the northern boundary are exceptionally small and plotted on a redeveloped site where the entire northern buffer was surveyed into a stockpile full of disturbed soil stripped of all natural vegetation. You've seen previous pictures in other presentations, and I showed pictures in my original presentation. There was no vegetation left behind. The practice of leaving a steep grade, unvegetated stockpile consisting of disturbed soil at the edge of a site or development is a negligent, cost-saving measure that should never have occurred on the lots as small as these. It left the homes on the northern boundary with a net zero stormwater drainage capability. The lots on the northern boundary homes were in essence a flood zone after every heavy rain event. Contaminated stormwater on the northern boundaries had nowhere to go after the heavy rain event except straight into the open air ground floor swimming pools. All of the variance requests submitted by the homeowners on the northern border had identical retaining wall or pervious paver patio stormwater drain systems installed after issuance of the CO in order to provide the homes with a highly functional stormwater drainage solution that was desperately missing at the issuance of the CO. The town has continuously failed to provide evidence that these drainage systems on the northern homes introduced a negative stormwater impact to the subdivision because the evidence does not exist. In the November 23rd BZA meeting, Mr. Charlie Walczak stated that stormwater calculations should be ordered for the currently installed stormwater drainage systems on the northern boundary in order for the board to make a fair and accurate decision regarding the positive or negative functionality of these systems. At the conclusion of that November 23rd meeting, Ms. Lisa Loudermilk made a motion that the quorum approved the motions for reconsideration for 119 and 123 Sandcastles on the basis that there was information presented in the prior variance consideration meeting that was overlooked and not clearly understood. I am respectfully asking that the same motion be made for my petition on the basis that there was information presented in my prior variance consideration meeting that was overlooked and not clearly understood relative to the stockpile and relative to the positive functionality of the currently installed system for stormwater drainage. The stormwater calculations Mr. Walczak requested have been ordered, and the northern boundary homeowners should will be presenting these findings given the option to have a reconsideration. Thank you very much for your time. That's all that I have to present.
Thank you, ma'am. And my apologies. I skipped over the part where the staff would make their presentation first, so we will give them the opportunity to do that. I'm sorry, I skipped over one section on my outline. But I think since Ms. Barnum has made her presentation, it would be an opportunity for board members to ask her questions. So again, we follow a rotation schedule. And this time, Mr. White, you would be up first to ask Ms. Barnum questions on behalf of Mr. DeVito's application.
Okay. Thank you, Madam Chairman. Ms. Barnum, you were mentioning the fact that you have an intimate understanding of builders and developers. Is it not true that anybody purchasing property would get an as-built survey?
Yes, it is true. And on the northern boundary homes, I think if you were in the meeting last time, on the northern boundary homes, there was much question as to certain as-built surveys. There were several surveyors involved, and there were a multitude of confusing as-built surveys presented. Some homeowners had the buffer line on their as-built surveys, and some of them did not. In my case, the individual that I'm representing, his as-built survey did not have the buffer line accurately displayed on the as-built survey.
Mr. White, any other questions?
Yeah, I guess I'm finding it difficult to understand that as many people that touch a purchase contract, nobody caught the fact that there were no setbacks or buffers.
I would have to agree with you. I mean, yeah, I would have to agree with you, but I also would have to say that I strongly feel that setbacks and buffers is something that is up to the town planners. And when those as-built surveys were obtained, I would think that that would be something that would fall on the onus and responsibility of the town, because that's what that department is for.
Yeah, but the flip side is that you're dealing with a bunch of individuals that are spending a great deal of money to purchase a property.
Mm-hmm. Oh, and I agree with you. I think that there was information already presented earlier in all of these proceedings that showed that in order to put in an outside patio, you don't need a building permit. So I don't think that any of these individuals ever even thought to ask the town. And if they had a survey, which in our case, like our home that I'm talking about right now, the survey that was provided to them had no buffer on it. And because you don't need to apply for a permit in order to put in a patio, there was no check system involved outside of the as-built survey.
Okay, thank you.
Mm-hmm.
Yes, sir. Ms. Loudermilk, any questions of Ms. Barnum by you?
No, I do not have any.
Okay. Mr. Walczak, any questions of you?
Just to follow up a little bit, patios are one thing, but retaining walls are another. So, that's where the rub comes in.
Well, it's already been established that you guys have agreed that you'll let the retaining walls stay. I think the only thing in question right now is the patios.
Right now, as far as I know, nothing's staying. We've not granted variances for any of this.
I mean, my understanding was that the town had agreed that the retaining walls were able to stay because they ultimately, at least on the northern boundary walls, had prevented the runoff from the stockpile that was left behind, and that the only thing that was really being argued here was whether or not those patios were going to have to come back and have vegetation re-put in place.
Okay, can we hear from the town on that? Anyone?
Sure, this is Nicole Dixon. Two things. One, I would like to just clarify about the retaining wall. The LMO specifically says in the definition section that there are no setback requirements for retaining walls. And when myself and Terry Lewis discussed the situation and that section of the LMO, we decided that the retaining wall can remain in the buffer because the buffer can still function as a buffer if it's planted like it should be. So what we had told the applicants was that they can keep their retaining wall, but they have to pull the patio out and plant the buffer as it should be planted. And then the second thing I wanted to bring up was just the confusion about the as-built and the plat. The as-built survey that the applicant is talking about, those surveys are done after the home is constructed. So the plan and the plat that the property owners should be looking at in order to develop their property is the subdivision plat that was recorded. They should not be relying on an as-built survey. That's done by a surveyor just after the building is constructed to show where the improvements were made. So whether they have things labeled or not on there correctly, the planners are not looking at that after the fact. The building inspectors are looking at that to make sure that the home was constructed where it should have been per approved plans, but that is not something to rely on as far as future development. They should be looking at their subdivision plat, which accurately shows where their setback and buffer requirements are.
Any other questions of Ms. Barnum by the board? I do not have any questions. At this time, I think it's appropriate to let the staff make their presentation regarding this request. And again, I apologize for going out of order. For the next applicant, we will have the staff presentation first. So I would call upon the town staff for their presentation. That's Ms. Lewick and Mr. Newman.
Staff does not have a presentation. We just have the procedures as part of our rules for these petitions for reconsiderations. All 6 of the applications were denied by the BZA, and it is within the rules that they have the opportunity to petition for reconsideration, and the staff does not have any additional information related to these petitions to share. Thank you.
All right. I think that our outline calls then for the Grandins to go ahead and make their presentation, and after all the applicants have made their presentation and have been an opportunity for rebuttal, then we will move to our discussion and motions and vote on them individually.
Madam Chair, this is Nicole again. I just
Yes,
wanted to remind you all that Brian Eber is on the phone or on the call and is available for any questions related to stormwater and some of the claims that were made by the previous applicant. So he's available to talk or answer any questions that came up. So I don't know if you want to call on him to be able to rebut some of what was said, or you want to wait till there's discussion by the board.
I think that we can do that now if the staff wants to make that a part of their presentation, or if
Yes,
the board
we would
has
like to.
questions. Okay. All right. Then Ms. Dixon, are you going to be making a presentation as well, or do we call?
No, I'm just calling on Brian Eber to talk stormwater.
Okay, this is part of the staff presentation. Okay.
Yes, ma'am.
Go ahead, Mr. Eber.
Thank you again, Madam Chairman. I had a chance to look at the subdivision design was submitted to the town in 2005. There were plans at that time that showed rough outlines of buildings and roads, and importantly, it also showed grades and existing stuff you might find in the field. So on the north property line, there, interestingly enough, there was what they labeled a berm. Putting this together, also noted that on top of that berm was a fence. So if you go out today, it's still the fence that's out there that's on top of the berm still seems to be in place, and that's basically Sandcastles' northern boundary limits, and it hasn't really changed a great deal from that time. The berm, though, is only about 2.5 feet tall, so it's not a very tall berm. But on one side, water runs onto Sandcastle property, and from the other side of the berm, it runs onto town-owned property. The berm's probably about 2.5 feet wide that drains onto Sandcastle, and then it's about approximately the same size as the town property. So all in all, it's about a 5-foot wide berm running along the property line with a fence on top of it. And I bring that up into context. There's been a lot of the applicants have mentioned a spoil area. Well, that spoil area was a berm with a fence on it at the time before this subdivision was even created or developed in the 2006, 2007 time frame. So the plans call for that area to be a natural buffer, a 20-foot natural buffer. And had that been planted appropriately to buffer standards, no one knows what the runoff stormwater would have been with the built environment that they have today. But the stormwater calculations were submitted to DHEC to review based upon what they thought was going to be a naturalized 20-foot buffer, which generally speaking is a much reduced amount of runoff. The homeowners could have chosen to put a wall up at the 20-foot line and collect and move stormwater in directions around their house and down to the road, but they chose obviously to take a different path. And I'm here to kind of let you know that over time, these have a life cycle. Paver patios have a life cycle, and that life cycle shrinks over time, degrades. Its ability to allow water to permeate through the patio changes over time. It gets worse. If it's a natural system where you have plants and trees and bushes, over time it actually increases its ability to handle and manage and mitigate stormwater. One or two lots are going to dramatically affect the overall stormwater system, but if all the lots and all the buffers, whether it's the northern boundary or western boundary, were to take the same, have the same effect, it could lead to issues within the community that abut the stormwater maintenance facility. So I guess I just want to emphasize a little bit that while these patio pavers were built so that they would not have a lot of runoff relief from them, they will in time degrade, and they will in time actually will have to be maintained and redone as a direct result. Had it been naturalized, we would be in a different situation today.
Thank you, Mr. Eber.
Part of my testimony.
Okay. Anything else, Mr. Eber?
No, that's it, Madam Chairman.
I'm sorry, you're
no, that's all, Madam Chair.
Thank you. Sorry, the voice part got a bit distorted, so thank you. Board members, questions of Mr. Eber. Mr. Walczak, any questions from you?
No, thank you.
Ms. Loudermilk, any questions from you?
Yes, and again, not obviously being expert in stormwater runoff. I'm trying to just understand some of what's being discussed. Mr. Eber, did you say that the original calculations as to stormwater runoff were done based on the assumption of a vegetated buffer?
Yeah, as a natural buffer, not so much as grass. I would have thought that a naturalized buffer would have included bushes, native plantings, not grass.
You're a little fuzzy on the audio. So you're saying it was on the assumption of native plantings?
Yes, ma'am.
Okay.
Yes.
And now this goes back to what Ms. Dixon said. I do think we were unclear in the prior meeting that there was in fact across the board agreement as to the retaining walls being permitted to remain. Do the retaining walls serve the same purpose or result in the same effect as having a vegetated buffer?
The retaining wall impede more natural native plants from being intended.
Your audio is bad again.
Hold back. Sorry. Maybe I should call in.
Brian, I'm sorry to interrupt. This is Teresa, the BZA secretary. Brian, if you wouldn't mind dialing in from a cell phone.
Okay. Yeah, that'd be fine. Let's give him just a moment to do that so we can get more clarity with regard to the audio from Mr. Eber. So bear with us just a moment, folks. We'll get Mr. Eber to join back in by another means. I think I saw Mr. Walczak leave. I know he was having some perhaps signal issues. Let's see if Mr. Walczak will come back. Mr. Walczak, are you there? Ms. Haley, can you or another staff member try to connect with Mr. Walczak to see if we can get him back? We
Yes,
will need
ma'am.
him for the quorum. Thank you.
Of course.
Any luck, Ms. Haley, with finding either one of those two folks?
We are currently on the phone with him right now, and we'll report back. Thank you.
Thank you.
Madam Chair, we have Mr. Walczak back on. He was having some technical difficulties.
Yes, ma'am. Thank you.
I'm back. I'm back. Sorry.
No, it's okay. Thank you. I think then we have our quorum back again, only lost momentarily due to technical difficulties. Now we're trying to get Mr. Eber available, and he was addressing a question from Ms. Loudermilk. Just let us know when Mr. Eber is available again. Any luck yet with Mr. Eber?
I believe Mr. Eber has just signed on.
Okay. Mr. Eber, are you there?
Eber? Brian?
Hello?
Brian, if you're there. Yes, Brian.
Yes,
Hello?
Mr. Eber. Yes, sir. Sounds like
Wow,
Mr. Eber.
that was yes, this is me. This is me.
Okay, great. You were addressing a question from Ms. Loudermilk. If you want to continue to do that, or if we need to restate the question.
Yeah, at this point, to be fair to her, I want to, if she could restate it so I can properly address it.
Oh, that's a challenge.
Yes.
What I was trying to, I think, ask is, one, the original stormwater runoff calculations, one, were they based on the assumption of a natural vegetated buffer, which apparently never really existed, but were they based on the assumptions of the vegetated buffer? And then 2, now that there is a retaining wall in place, and if we are understanding staff correctly, the retaining wall is permitted to remain. Does the retaining wall serve the same purpose or accomplish the same runoff mitigation as was originally anticipated?
Very good questions. I would say that in the original calculations, the assumptions were made that this was going to be a natural vegetated buffer. It would not have permeable pavers, it would not have any sort of patio, nothing to that end. Then the next question becomes, what's the intent of the wall? The intent of the wall is essentially to hold back the earthen berm. And by holding back the earthen berm, is it harming or hurting or impacting the stormwater in a negative way? And I would have to say no.
Okay, so again, in your opinion, there's no negative impact on runoff from the retaining wall?
Correct.
Okay. Is it safe to say it's a positive impact from no and it sounds like I'm leading the witness. Is it safe to say that it would be a positive impact from no retaining wall and no vegetated buffer? I mean, there is some positive result from this retaining wall?
By all means, the existing berm out there, as pictures have shown, over time, without any vegetation on it, would have eroded and would have ended up on people's properties outside the buffer. So it was not something that was assumed that was going to be necessary, because they assumed everything was going to be natural plantings and bushes and such and trees, and over time it would get better. But it's definitely an improvement over what was existing out there. Absolutely.
Okay. All righty. Good. Thank you.
You bet.
Okay. Mr. White, I've lost track. Did I ask you for any questions of Mr. Eber?
I have no questions.
Okay. Thank you. Mr. Eber, in follow-up to the questions from Ms. Loudermilk, other than a retaining wall, are there other means, such as by plantings, to help maintain the stability of the berm?
Yes, there could be. It would involve the use of a licensed landscape architect to provide some soil stabilizing plants on the berm. That way its roots could also act as an anchor for that berm. Its leaves could act as impact resistance to the stormwater that fell. And so it could be considered a system of naturalized reduction of impacts to the erosiveness of the berm. But a retaining wall is another item, another choice at the same time.
Okay. Thank you, sir. Those are my questions of Mr. Eber. But I do have a follow-up question from Ms. Dixon. Ms. Dixon, you indicated that the staff has decided that the retaining wall could be located within the buffer area. How about the setback area?
Yes, ma'am.
Okay, so the retaining wall, is that still at issuance with, is that still at issue with regard to the variance request?
No, it's the patio encroachment that I believe the applicants are all requesting to keep.
Okay. All right. And that encroachment is both in the buffer and within the setback?
Yes, ma'am.
Okay. All right. Any other questions of board members of the staff? Okay, then, and Ms. Haley, help me if I get offline on the outline again. I'll try not to do that, but the next presentation then would be by the Grandins for 115 Sandcastle Court. Ms. Haley, am I okay now?
Yes, ma'am, you are correct.
Great, thank you very much. Mr. and Ms. Grandin, it's your opportunity to make a presentation. You have 20 minutes and you may proceed.
Thank you. Good afternoon. We're also on the northern boundary as homeowners there with the same circumstances that have been presented in the previous petition for reconsideration. The owners at 119 and 123, which were approved last month, are again very similar to us. And we respectfully ask that the same motion be made to grant our petition on the basis there was information presented in our prior variance consideration that was overlooked or maybe not clearly understood relative to the stockpile and to the positive functionality of the stormwater draining system that we have put in to help alleviate the problems. Again, we could rehash everything you've heard over and over. I don't think that's necessary. I think the thing to remember also, ours is on the northern side. We don't have the same issue with the Hilton Head beach and tennis. So I just want to make sure we're not all lumped into the same thing that may be an issue there wouldn't possibly be an issue on our home. So again, we're just hoping that we could be granted the approval to be reconsidered and be happy to answer any questions about our home.
Okay. Let's go through then questions by board members. Ms. Loudermilk, it's your turn in rotation to ask the first question.
No, I have no other questions.
Okay. Mr. Walczak.
No questions.
Mr. White.
No questions at this time.
I don't have any questions either. Let's move then to the next applicants, Mr. and Ms. Berks. I'm sorry?
Thank you for your time.
Yes, ma'am. Thank you all. We'll be back to you with our discussion and consideration of yours shortly. Mr. and Ms. Berks, 125 Sandcastle Court. Again, you have an opportunity to make a presentation with a time limit of 20 minutes. Our timekeeper is Ms. Haley. You may proceed.
Thank you very much. Our home is also on the northern boundary of the Sandcastle Court subdivision. Due to the exceptionally small lot, our home should be considered as at the conclusion of the November 23rd, 2020 BZA meeting, petitions for reconsideration were granted and approved by the quorum for adjacent northern boundary subdivisions at 119 and 123. We have exactly the same identical situations. The lots on the northern boundary are relatively small and plotted on a redeveloped site, berm hill or not, and I would take exception to the comments about the size of the berm. The berm is actually 3.5, 4 feet high at least, not 2 feet, and it's probably 6 or 8 feet in terms of the length that it runs on my side of the property. The lots there is a stockpile there. They were stripped of all natural vegetation. Native plants were not planted unless grass is considered a natural vegetation. The practice of leaving the steep, ungraded, unvegetated stockpile created a negligent cost-saving measure, should have never been approved on our lot. Its homes left net zero stormwater drainage capability. They were, in fact, the flood zones. All the variances requested from the northern boundary had identical retaining wall, pervious patio stormwater drainage installed after issuance with a highly functional stormwater drainage solution. As we previously applied for the variance, we said we would be happy to put in any vegetative plan that would be required by the city or by the town. If that includes getting a licensed landscape architect involved, I'll be happy to incur that expense. as a result of, some of the comments that were made at the last board meeting, I think it was Mr. White that said, this is a really big kettle of fish. And Mr. Wolzak said we should change the buffer line. I wish that we could get everybody to approve and consider the variances and the replatting of the neighborhood. I would ask for the same consideration that Ms. Loudermilk gave the 119 and 123 Sandcastle homes, based on the fact that there was information that was overlooked or not clearly understood. And we request that that motion be made for my petition on the basis that there was information in the prior variance consideration that was overlooked or not completely understood relative to the stockpile and installed stormwater drainage system. And would ask your consideration and your affirmative votes for a reconsideration. Thank you for your time.
Okay, thank you, Mr. and Ms. Burke. Opportunity now for questions from the board. Mr. Walczak, you're up first this time in rotation. Any questions?
No question.
All
No question.
Thank you. Mr. White.
I don't have any questions.
Ms. Loudermilk.
I don't have any questions of the Berks. I do have a question for Mr. Coltrane. Should I hold that for discussion?
Unless it pertains to the Berks, I'd say so, because we will get to consideration and action on each of these requests individually, but after all have made their presentations. Unless it will help you with reviewing the presentations at this time.
Well, I guess it pertains to the Berks. It would pertain, frankly, to all of the applicants, but it clearly would pertain to the Berks.
Well, I'd say if that would be helpful, go ahead and ask Mr. Coltrane.
Okay. Okay, Mr. Coltrane. For the purpose of what we're considering today, the motion to reconsider, the information that we are receiving and understanding, primarily, I guess, from Mr. Eber and also Ms. Dixon a little bit, but all the information relative to the stormwater runoff, the impact of the retaining walls, etc. Is that information that is pertinent to the purpose of whether or not we grant a motion to reconsider?
Not sure I understand your question.
Let me try to think of how else to phrase it. If the information we're receiving from Mr. Eber and Ms. Dixon is expanded information over what we heard in the initial presentations a meeting or so ago, then that is justification for us to consider the motion for reconsideration. Is that true?
Well, you have an obligation to consider the motion because in this instance, for example, the Berks have brought it before you. The question that you've asked, though, in if I understand it correctly, though, is more directed to, is the evidence and material that's been placed before you today sufficient for you to grant it? And that is, of course, solely your province as to whether or not you are convinced that the materials you have heard today rise to the level set out in Article 11 of your wait a minute, Article 11 of your rules as to whether or not there's something you've heard now that causes you to believe that the matter should be reheard. I mean, if you believe that what you've heard today sends you that way, then yes. If you don't believe that, then no. But that's a decision each board member has to make based on their own view of what they've seen and heard.
And your
Stormwater
answer.
calculations that Mr. Walzak asked for has been requested.
I'm
So
sorry.
that was progress from the previous meeting.
I'm sorry, is that Mr. Burke? If we could ask other folks to mute their microphone at this time, so that we can make sure that we understand the exchange between Ms. Loudermilk and Mr. Coltrane. Thank you. Okay, go ahead, Ms. Loudermilk.
No, I think I understand Mr. Coltrane's answer. Yeah, let's leave it go at that, and we can have it in discussion then if necessary.
Okay, all right. I think we were to questions of the Berks. And Mr. Burke, I think you were wanting to add something to your presentation. Let me first check. Ms. Haley, is there still time available for the Berks within their 20-minute time period?
Yes, ma'am.
Okay, Mr. Burke, you may proceed.
Thank you, Chairwoman. The stormwater calculations that Mr. Walzak has requested have been ordered for the northern boundary home. If we're given the reconsideration hearing, we should be able to present those at that time. We were told not to present new evidence at this point, but to simply ask you to reconsider your vote. And in conjunction with what you granted Mr. Schneider and the other applicants at the previous meeting, we're asking for that same consideration to come back before you with new evidence at the appropriate time to make sure that there's no misunderstanding about what it might have been overlooked or misunderstood. So thank you very much.
Okay, thank you, sir. Any other questions by board members of the Berks? Okay. Thank you, Ms. Burke. Now we'll move on to the next applicant. And I apologize if I mispronounce anyone's name, but Mr. Kazbov, did I say that correctly?
Yeah. Hello?
Yes, sir.
All right, perfect. There we go. All right. As you guys know, I'm also on the northern boundary, and we're all in the same boat. So my statement would be very similar to everybody else's. Let's see. Okay, my home is on the northern boundary of Sandcastle Court subdivision. Due to the extraordinary and exceptional site conditions that exist on my 0.07 acre lot on the northern boundary subdivision prior to the issuance of the certificate of occupancy, my home should not be held hostage to the same. Rubber stamp findings of the fact or conclusions of law apply to homes on the other outside and inside boundaries of the subdivision. At the conclusion of the November 23rd, 2020 BZA meeting, petitions for reconsiderations were granted and approved by the quorum for my adjacent northern boundary subdivision neighbors at 119 Sandcastle and 123 Sandcastle. The owners of 119 and 123 have the identical situation to me. The lots on the northern boundary are exceptionally small and plotted on a redeveloped site where the entire northern buffer was surveyed into a stockpile full of disturbed soil, stripped of all natural vegetation. The practice of leaving a steep grade unvegetated stockpile consisting of disturbed soil at the edge of the site development in a negligent cost-saving measure that should never have occurred as on lots as small as ours. It left the homes on the northern boundary with the net zero stormwater drainage capability. The lots on the northern boundary homes were in essence a flood zone after every heavy rain event, contaminating stormwater at the northern boundaries and had nowhere to go after the heavy rains events except straight into the open air ground floor swimming pools. All of the variance requests submitted by the homeowners on the northern boundary had identical retaining walls and impervious patio stormwater drainage systems installed after issuance of the CO in order to provide the homes with a highly functional stormwater drainage system that was desperately missing at the issuance of the CO. The town has continuously failed to provide evidence that these drainage systems on the northern homes introduced a negative stormwater impact to the subdivision because the evidence doesn't exist. Let's see. In the November 23rd BZA meeting, Mr. Charlie Walzak stated that stormwater calculations should be ordered. I guess that's the new information that we're waiting on for the last people that just spoke. And at the conclusion of the November 23rd, 2020 BZA meeting, Ms. Lisa Laudermilk made a motion that the quorum approve the motions for reconsideration for 119 and 123 Sandcastle on the basis that there was information presented in the prior variance consideration meeting that was overlooked and not clearly understood. I respectfully ask for the same motion to be made for my petition. On the basis that there was information presented in my prior variance consideration the meeting that was overlooked and not clearly understood relative to the stockpile and relative to the positive functionality of my current installed stormwater drainage system. The stormwater calculations Mr. Walzak requested have been ordered, and the northern boundary home owners should present these findings of fact into the record together in a unified meeting, future meeting. Thank you for your time. That should be everything. Yep.
All right. Thank you, sir. This time it's opportunity for questions by the board members. Mr. White, any questions from you?
No, ma'am.
Ms. Loudermilk, any questions from you?
No, ma'am.
Mr. Walczak, any questions from you?
Yes, I'd like to know what new evidence are you presenting today?
We were told not to present the new evidence, and that's
isn't
what
that
we were
the
told.
purpose of today's hearing, is to present new evidence?
Okay. I mean, this is the same statement that everyone previous to me read out.
And it's a little repetitive.
Yeah.
I think, Mr. Walczak, that would be a question for Mr. Coltrane based on what our standard is for consideration today. And you can either ask him now or wait until we have our board discussion on the individual.
I'll be glad to ask Mr. Clerk. Isn't the purpose of today's meetings to present new evidence?
No.
No?
Sorry. No, I'm sorry. There's someone in the, can we ask everyone to mute their microphones except for Mr. Walczak and Mr. Coltrane?
Did you hear me?
My understanding was not to present new evidence because
Mr. Casbah?
Yeah.
Sorry. Yeah. If you could hold up, sir, if you could mute your microphone, and let's let Mr. Walczak ask his question of the town attorney, Mr. Coltrane. Okay, Mr. Walczak, you may proceed.
I think you heard what I said, but I'll say it again. Aren't today's meetings for the purpose of presenting new evidence in trying to resolve these disputes?
Well, the purpose of the petition for reconsideration is for the applicant, in this case, Mr. Kasbah, to demonstrate facts or evidence or law that the board misapprehended or missed when it heard the matter as an initial thing. If the board concludes that, yes, there were things that the board misapprehended or missed in the initial hearing, then the matter returns to the board for essentially a new hearing, at which time they put up whatever evidence they're going to put up. Now, I agree that this isn't for the purpose of putting up the new evidence. It's for the purpose of demonstrating to you that things were missed at the first hearing that afford them the opportunity to do that at a subsequent hearing. He wasn't he's correct that they weren't to make a new presentation of new evidence today. Today is whether or not you have been convinced that there were things missed by the board or misinterpreted by the board at the first hearing that cause you to believe that a new hearing is in order.
But now I'm understanding we're going to have to come back another time because of drainage calculations. Is that correct?
Well, if the petitions are granted, you will have to come back, and the applicants will make whatever presentation they deem to be appropriate for them at that time.
All right, so let me understand this. In other words, the purpose was just to appeal or to make the statement that we didn't really understand what they were saying the last time, so they wanted to come back and reiterate it? Is that what today's is for?
I wouldn't phrase it like that. I would phrase it that the applicants believed that there were important matters of fact or the law that the board misunderstood, misapprehended, or missed the first time around that should be considered by the board, and that they should be given an opportunity to present those matters to you.
Okay, well then why wouldn't they explain to us how they feel we've misinterpreted these terminations? I haven't heard that.
Well, I don't think be appropriate for me to comment on the presentations that the applicants have made. I mean, that's the board's province.
Well, that's what I'm saying then. I'm making that determination. That's what I'm saying. All we've heard is a rehash of what they said the last time, and that they didn't like the result. I didn't hear any new evidence to say, well, the reason you misunderstood this is because. I didn't hear that.
I think Mr. Walczak, as Mr. Coltrane is saying, then that's for the board to decide based on the standard he's explained. And we'll do that as soon as we've heard all the presentations and then vote individually on each petition, each motion. So right now you're giving us more of where you're headed as opposed to listening to the presentations and then we decide where we're headed.
Okay.
Okay. I'm sorry, Mr. Burke, it's not time for you to speak at this time. Okay. Ms. Loudermilk, did I give you an opportunity to ask questions? I'm sorry.
I don't have any.
Okay. All right. Thank you. And I do not have any questions at this time. So thank you, Mr. Caswell. We'll be back to when we consider your petition for reconsideration later. Let me check in with the board members. We've been at this for almost 2.5 hours, not quite, but we have Mr. Ross coming up with 2 petitions for which you can have a total of 40 minutes. Would the board like to be in recess for personal privilege for a short amount of time or to continue? Any sentiment by board members?
I would say,
Mr. White, go ahead.
I'll vote for continue.
Yeah, so will I. Let's continue.
Well, to continue. Okay, all right. I'm sorry. Mr. Walczak, okay with you?
I abstain.
Okay. All right. Well,
no, we'd like to finish at a reasonable hour, not like last time.
Right, press on. Okay, we will press on. We're not continuing anything. We're gonna proceed with our meeting then without recess. Okay. All right, Mr. Ross, then it's up to you for your petitions for reconsideration for 121 and 127 Sandcastle Court. You would have 20 minutes per property for a total of 40 minutes. I understand that your petition was made for both properties at the same time. So with that, we will ask Ms. Haley once again to be our timekeeper. You can choose how much of those 40 minutes to take, but I would hope that you would be judicious in the expenditure of that time. So, Mr. Ross, you may proceed. Ms. Haley, you may start keeping the time.
Okay, can everybody see and hear me?
Yes, sir.
Yeah.
Okay. I'm the owner of 121, 127 Sandcastle Court. I'm on the northern boundary homes. And I just wanted to go ahead and give you my presentation here. And before I start, just wanted to thank you for your time. And I'll try to keep this as brief as I can and still give you all the information that you need to be able to make a decision. I was under the impression from the last meeting that this meeting was to give you no new evidence, that wasn't allowed in this meeting. The new evidence could not be presented, but the only way that I could get a new hearing was to describe why my last hearing basically turned out with a no verdict on it. So Mr. Walzak, on this presentation, you're going to hear why I think things were misunderstood at the last meeting. There is no new evidence because I was told that I could not have any new evidence. The town of Hilton had, put the board in a very difficult position last month. The town pushed you to make a decision on a variance without giving you the proper information to be able to make an informed decision. The matters got worse because this town staff purposely gave you false and misleading information in an attempt to sway the decision into their favor. And because of this, key facts were overlooked and key points were misinterpreted, which unfortunately led to the board's denial of the variance. First, I just wanted to quickly point out what facts were misinterpreted by the board that would have supported my variance. The most important one really is with regards to criteria 1. There are extraordinary and exceptional conditions pertaining to the piece of property. The town acknowledged in the last meeting that an illegal stockpile was left by the developer, yet the town did not acknowledge that this was an extraordinary or exceptional condition. And I have to disagree with that. There's not a single residential lot on Hilton Head Island that has an illegal stockpile in the backyard causing flooding into the residents' homes. This fact alone causes us to meet all 4 criteria for the variance. The board misinterpreted this key point due to the deception and misleading information from the town staff. And then we can go on to criteria 2, is the same problem. Criteria 2 was these conditions don't generally apply to other homes in the vicinity. This is where the town really goes off the reservation and seriously misleads the board by incorrectly determining what the vicinity is. And it's just a deliberate misinterpretation on the town staff report. The town has absolutely no case against us unless they cheat and they call the neighbor with the same illegal stockpile the vicinity. The claim is just absurd. The common sense dictates that you can't label my neighbor with the same problem as me as the vicinity to disprove criteria 2. Now, I know, Mr. Walzak had brought up, the fact that, the definition doesn't have to be what's on the plan or the vicinity as on an as-built. And even though I showed that as evidence that, it's the vicinity, what I was really trying to say and what was misunderstood was it doesn't really matter what the legal definition of vicinity is. What really matters is what was the intention when they wrote the LMO of the vicinity. And the intention the LMO had when they were writing that ordinance is they wanted to take somebody that had a real problem and it really didn't apply to everybody else. And when they mean everybody else, they mean everybody else around them, not their neighbor that had a problem that was so large that it actually went outside of their property and affected their neighbors. The intent of the LMO was to try to give a variance and provide relief to someone if they could show that their problem did not affect other people in the vicinity. So I really think that they need to look at the vicinity as what the LMO intended. And what the LMO intended was if we had some huge problem in the northern boundary of Sandcastles and it doesn't affect Folly Field and it doesn't affect anybody else in the island or in Bluffton, but just 7 homes that are adjacent to each other that had a huge stockpile left over, that's what the intent of the LMO meant by when they said vicinity. They meant that the vicinity is others around you, not your neighbor with the same stockpile. So I think that was misinterpreted, and you really need to look and not listen to the town when they're talking about my neighbor. They need to listen to what the LMO actually was intending. So, I also want to just kind of recap what happened during my hearing. After both the town and I presented our cases, the majority of the board were proposing to grant a variance with 2 conditions. And it was a very positive beginning to the meeting. I mean, everyone was seeming to agree that they could pass this variance with the conditions that the property owners did extra heavy vegetation to our properties, to the buffer that exists, and also provide a favorable runoff calculation that would give the board some assurances that the homeowners' walls and patios didn't create a water runoff issue. You know, to get these reassurances, the board turned to the owners in the town for answers during the meeting. And obviously, the owners said that we would be more than willing to extra heavily vegetate 2-3 times what the LMO requires for the existing buffer that we have. But then the board was still in need of information on this water runoff issue. So rightly so, the board was worried about our improvements maybe affecting the water runoff, so they turned to the town for some testimony from Mr. Eber. But what happened is that Mr. Eber wasn't available for testimony, and I believe that he was missing in action on purpose. You know, Mr. Eber's the rainfall expert on the town. Mr. Eber's the only one that's come to our backyard and has actually seen the improvements. And if Mr. Eber determined that we negatively impacted the rainwater runoff, the town would have had him front and center in our meeting testifying against us, but they didn't. Instead, they nominated Tyler Newman to be the new water runoff expert. And that's not fair because Tyler Newman does not have a civil engineering degree. He doesn't know anything about water runoff, and he's never actually ever even seen our improvements. Yet he's testifying during my hearing that, like, quote, it seems like the improvements would increase the runoff. He doesn't have any basis for any of those kind of comments. And that was kind of entered into by the town as testimony, which confuses everyone on the board and should not be appropriate testimony when there's someone there that's actually seen the yard and isn't present during the testimony. So I really think that was intentional by the town of him to be able to testify. And you know, unqualified town staff employees were misleading the board, and I think it negatively impacted your decision-making capability. The town's also at fault for insisting to combine these northern boundary homes with non-northern boundary homes during the same BZA hearings. This created unnecessary confusion, you know, for the board. You know, the town combined their own presentation for all these properties, and it misled the board to think that the northern boundary homes had similar circumstances to all the other homes in Sandcastles seeking a variance, which simply isn't true. The town also made the board think that if they approved our variance on the northern boundary, they'd have to approve all the other variances, which is completely incorrect. All these variances have to be considered and voted on individually, and circumstances of other properties in the neighborhood seeking variances should have no bearing on my variance outcome. You know, the board overlooked this fact. In fact, the board made numerous statements in the last meeting that indicated they'd have a hard time granting the northern boundary a variance and not giving the same variance to all these other people in the neighborhood. There shouldn't even be anything coming up in the discussion about other homes in the neighborhood. This is my time to come argue my situation on my property and how I feel that I need a variance and it should be granted. It should have no bearing on all these other properties asking for variances that are not my property should not even be entered into the discussion. Yet we kept on having comments like, well, what are we going to do if we give you a variance and then XYZ property down the road gets a variance? And then everything just started going off track about what's going to happen when everybody else gets one. I think there was a comment like, gee, the luck of the draw of being on the northern boundary, you get a variance. Well, there's no luck of the draw of anything. The northern boundary homes have giant stockpiles in the backyard that are causing flooding into the homes. That's not something that's on any other home that is requesting a variance. So I think the board got confused that they need to be treated individually and voted on individually And one circumstance of one property, other than the 7 that are all exactly the same on the northern boundary, they should not determine their outcome of these northern boundary homes based on what will the other people think that may not get one or might get one. So I think there was a lot of confusion because the town combined all of these. And I think they combined them on purpose because it causes great confusion. If this was all separated like I had suggested, this would be much more organized. We would have had the 7 boundary homes all by themselves. They would have got granted variances, and then we would have moved on to other houses with different circumstances. So, I mean, you just heard today, some people have property stakes in the lagoon. Other people don't have walls. Other people are against other neighborhoods. They're all totally different, and yet the town seems to be lumping us all together, and that's making it very difficult to resolve the situation fairly or promptly. So, another thing that I wanted to bring up is that I believe the town's attorney failed to act properly during my variance hearing. I think his actions negatively affected the outcome of my case. The town's attorney should be limiting his input to procedural law only during my hearing. And instead, he repeatedly gave negative examples and made suggestions of the board that I believe were intended to steer the board members toward a decision of denial. The majority of the board members were on the verge of conditionally approving a variance with conditions for the homeowner, as long as we could produce a favorable water runoff report. And then the attorney stepped in. And the attorney inappropriately, I feel, told the board that they should not make the homeowners incur an additional expense for a drainage report. The attorney went on to say that the board members should just go back and relook to see if we meet the 4 criteria for a variance. And that really implied that maybe they didn't, look at the criteria carefully enough the first time. And then if they go back and look at these 4 criteria, maybe they'll find somewhere where we don't meet that, and then you don't have to worry about this drainage report and waste all of the homeowner's money on getting a drainage report. And I think that was completely inappropriate on the part of the attorney, because everybody in that meeting was talking about how, well, yeah, I could pass a variance as long as we can get an appropriate drainage report. And then after the attorney spoke, everyone's like, oh, no, we don't want to cost these homeowners any more money, so yeah, let's not have them do the drainage report, and they just denied everything. So, but what doesn't make any sense is the attorney is saying that we should not get a drainage report, make us get a drainage report. The drainage report costs $500. If the 7 owners of the homes on the northern boundary have to tear out their patios and move them 24 inches, it's going to cost $50,000 to do that. And the attorney is telling us that we shouldn't make us spend $500 to get a drainage report. So, in closing, it was a real shame, that the board wasn't able to pass their original idea of granting a variance with conditions of extra vegetation and an acceptable drainage report. The idea the board came up with would have been an excellent compromise and a solution for all the 7 northern boundary cases before them. Instead, the town staff refused to allow the town's runoff engineer to answer board members' questions, and instead let unqualified town staff give false and misleading answers in subjects that they weren't educated in at all. And it's really unfortunate the town's attorney took an active role in altering the outcome of the decision of the board, which was obvious. I wanted to quickly address Mr. White's concerns that he had about why we let the builder leave a stockpile. That was some confusion during the last meeting, and I think I should bring that up. I think Mr. White asked, why are we paying serious money to a builder? We should hold them responsible for clearing the stockpile before we buy this home. It's a good question. It was misunderstood at the last meeting. We didn't hire a builder to build our home. We didn't ever own a lot. We're just simply buying a home built by a builder. We all signed a purchase agreement. We all gave a large non-refundable deposit. We all chose what options we want on the house. We all chose what colors we want. And that purchase agreement said that if this builder builds this house and they get a CO, certificate of occupancy, that proves they built the house and they met all the requirements by the town, that builder's fulfilled that part of the contract. So when I go to close on that house, I can't go in the backyard and point at a stockpile and say, remove that stockpile or I'm not buying this house. Because the builder's going to say, here's the CO, the town said it's okay, we fulfilled our agreement to build this house for you and we passed all our permits, either buy it or lose your deposit. So now, once again, the town has put us in a position where they have CO'd something they shouldn't have CO'd, and I can't get out of a contract because of a hill in the backyard. So that's the reason why we can't just walk in the backyard and say, just get rid of this, I'm hiring you, get rid of this pile. Because the town said that they didn't have to, and they issued them a CO. So that was the fault of the town, not the fault of the builder. So the other thing is that, and if I just said, well, if you're not going to remove that stockpile, I'm leaving. Well, they'll keep my deposit and move on to the next person that'll buy the house. So that's the reason why I can't just say, remove that stockpile, because that just won't work under this kind of purchase scenario. And the other thing is that when I did purchase the home, honestly, I'm not a civil engineer. I'm not a water runoff expert. There was a large slope in the backyard going toward the home. I did not have any idea that that was going to be as detrimental when I purchased the home. It didn't seem like it was going to cause a huge amount of flooding. Well, the day I bought the home, the next day we got torrential rainfall, and it was a huge problem. Water was, the berm was falling down with mud, and it was going all the way into the swimming pool. So when I looked to the left and I saw my neighbors, which I didn't know and I've never met, I thought they put all these patios in for just to have more living space, and so they look pretty. Well, that's not what it was. These patios were drainage control devices that were disguised as a patio because nobody had any water runoff and nothing in their pools, and I had a giant mess in my backyard. And of course, I couldn't have forecast that by just looking at a slope of some ground. So either way, the homeowners did not really know about this until they moved in, and then they put their improvements in to try to control this flooding. So, and for all these reasons that I just mentioned, I think I'm entitled to a new hearing. It's a real shame the town has insisted to continue on this strict enforcement of the LMO in a situation where a variance, is clearly warranted. I think some things were also misconstrued on, there was a lot of questioning in the meeting about why can't we build a smaller house? Well, the builder gave you a choice of 4 homes, and it's the 4 homes the town themselves approved. And we had no choice. We can't go, can we build a smaller one? They're all 4 of them are about the same size. All 4 of them have about the same footprint. And so there is no way to tell the builder, I want to build something smaller. They have 4 town plans approved by the town and pick one of them. So that's what we did. And there was another question sometimes. They said, well, why didn't you just move your house forward so you can have a bigger backyard? Well, once again, the town has put yet another restriction on these properties, which makes them even more unique. Now we have a resort angle roof that has to be done from the front of the street. And basically what that is it's a line from the street that goes at like a 45 or 30 degree angle, or I don't know, it's higher than that, but it's an angle from the street towards your house. And your roof, because of the resort roof angle ordinance of the town, you're not allowed to penetrate, your roof is not allowed to penetrate that line. So here's what the problem is. The town said, okay, we'll let you plat these really small lots and sell them. And we're going to put these buffer lines in the backyard, the side yard, the front yard. And you can't build a 1-story house because it'd be 500 square feet. So you got to build up. So they built up. So now they built 3 floors. And now they went, oh, wait a minute, you can't build 3 floors because of the resort angle roof. Because now the roof's going to hit the resort angle line. So now you can't move the house forward because you hit the resort roof line. You can't build less stories because there's no buildable footprint to have any square footage. So basically, between a resort roof line, a side setback, a rear buffer, a front setback, and the resort roof line, you can't basically build anything but what the builder offered. And that's why they had 4 floor plans to choose from. Because with all the restrictions the town put on these properties, you couldn't build anything. So that's why it was restricted to four pieces or four floor plans. So let me just continue with one thing. You know, Mr. Eber said, I think that the one thing that was also misconstrued on this variance hearing is I think it was a little bit misconstrued on what we wanted. I know there was a lot of talk about, you know, can't we just all get together and replat? That sounds great in theory, because the town allows it. The town allows us to reduce to a 10-foot buffer. So I think what wasn't understood is the town doesn't care about our retaining walls. We knew that when we had the first meeting. They don't care that the retaining walls are in there. And Eber just testified that they're helping. You know, I mean, that they help all the earth from falling down. So all we want to do is try to, basically what this is all coming down to is patio pavers. And, you know, we've put in a system with sand, you know, 6 inches of gravel and crushed rock, felt, patio pavers, and, you know, Mr. Eber was speaking in a lot of generalities, like, you know, generally speaking, I would say, you know, it could lead to issues. And he was saying that patio pavers, you know, have a life cycle, and that's not true. Patio pavers do not have a life cycle if they're properly maintained, just like any drainage system that you would put in. So, you know, if we have a patio paver system where we have a scheduled maintenance every 12 months to clean the grout lines to make sure that the drainage system is working properly, that's certainly something that can be put in as an order of the ordinance or the variance that we comply with. But patio pavers do not have a life cycle when they are actually properly maintained. So the other thing that I don't think the board understood is that we're allowed to reduce this buffer by 10 feet. Everybody's patios are about 12 to 13 feet. We're talking about 24 to 36 inches here. So I'm not sure that the board understands the scope of what we're looking for. Eber, the expert, went out there and said the walls are fine and are actually an improvement that helped. The town is saying that they're going to allow the walls. The town also says that we can have a 10-foot buffer reduction, but we can't do that for logistical reasons, and that's why we need a variance. And I'm not sure the board understands they're allowed to the board can grant a variance because of all these problems. They can give us this 10-foot buffer. We don't need to replat. Replatting is fine if you can get all the owners if we can find all the owners. But the interior of the neighborhood has nothing to do with the exterior of the neighborhood. And you're not going to be able to find all the interior owners and have them work together to try to replat exterior properties that they don't have anything to do with. It just isn't practical. They're not going to, oppose it, but they're certainly not going to go out of their way to, especially to pay for any of it and or be involved in it when it doesn't affect their properties. But we're allowed to reduce to 10 feet through a variance, and you're allowed to grant that variance. And it shouldn't matter. So, all this is coming down to is 13 feet of patio pavers now. That's all it's coming down to because the wall can stay. And we're allowed to do a 10-foot reduction. And that fixes 10 feet of patio pavers. So what became a huge drainage issue by the town, 10 feet of it is okay now if we just replat or if you give us our variance. 10 feet of those patio pavers are perfectly fine. So all this is coming down to is a 10-foot reduction that we can't get without a variance. And then we're 24 to 36 inches, depending on how much you measure the patios. 24 to 36 inches is what we're talking about. We're talking about 24 inches of patio pavers. That's it. In an area that can't be seen. So, if the board can just grant our northern boundary homes as they are, 10 feet of that was already allowed with a replatting. The retaining walls the town is allowing, and we will agree to do the extra heavy twice or 3 to 4 times what the LMO requires in our buffer that we have now. I mean, that seems to be what we were asking for in the last meeting, and it seemed to really be a workable solution for 7 of these cases, which is the majority of all the variances in front of you. But it seems to me that everyone seems to go, yeah, we should go the replatting route, but it would just be easier to grant the variance and then you would just be giving us an extra 24 to 36 inches of patio pavers in this variance just to keep from having a huge tear up of $8,000 of patio just to move it 24 inches. But it seems like that would be, I'm not even sure you need a drainage report because Mr. Eber, who's the expert on it, said that our improvements help the situation. The town and Nicole is saying that the wall can stay because it's helping. And the town is also saying that we can replat to 10 feet. So if we can replat to 10 feet, certainly you can give us a
Mr. Ross, let me interrupt you for a moment. I believe you're replowing the same ground. Let me check with Miss Haley about our time. Miss Haley, how much time is left, please?
14 minutes.
Okay, Mr. Ross, again, you have 14 minutes, but I believe you're replowing the same ground over and over again.
Okay, well, I just wanted to say that it seems like everyone is saying the same thing during all of these hearings. Everyone, or at least the majority of the board, very much wants to get this over with. They want it to come to a fair conclusion. They don't want to see patios ripped out. And they're trying to find a way that somehow this can work. And all I'm saying is I'm not sure that the board completely understands that if they just grant a variance with what we're asking for, it's coming down to just allowing 24 inches of pavers compared to us replatting, it's coming down to 24 inches of pavers. So it seems like it would be a logical step to just grant the variances on these 7 northern boundary homes and be done with it. Everyone walks away happy. And the only thing you're really granting that the town doesn't want is 24 inches of pavers. So, and given all the totality of our circumstances and the difficulty in building and the way that we met all of the 4 criteria, I mean, we spent hours and hours trying to convince you of the 4 criteria, and Ms. Lattermilk has been very articulate and taking notes and asking lots of questions. And, she gave a 2-minute presentation during my meeting about how we meet all the 4 criteria. And, she said in 2 minutes, basically what all the homeowners took hours to say. So it just seems that if we meet all the criteria and with the overwhelming amount of difficulty we have at our lots, it just seems like granting a variance and leaving everything in place and just to give us an exemption on what comes down to 24 inches of patio pavers seems like it's a very reasonable outcome for this. And that's all I have to say. Thank you.
Thank you, sir. This time it's an opportunity for board members to ask questions of Mr. Ross. Mr. White, do you have any questions?
No, I basically had the same question I had before, but with respect to acceptance of the property. But I thought Mr. Ross answered it quite well.
Okay, thank you, sir. Ms. Loudermilk, any questions of Mr. Ross?
No, I don't. I think the information was very succinct and useful.
Okay. Mr. Walczak, any questions of Mr. Ross?
I don't have any questions, but I'd like to just clarify a couple of things that he said. First of all, and again, this is not a question, but there is no definition of vicinity in the LMO. If you can go to section 1610-105, you won't find a definition for vicinity. So I just want to correct that. And the other thing you mentioned, you said that we've taken all of these applications and lumped them together, and it was the wrong thing to do. And I understand your criticism there. But the one thing that they all have in common is they all violated the LMO. So I just wanted to make those points. Thank you.
Okay, thank you, sir. I do not have any questions of Mr. Ross. At this time, it's the opportunity for staff rebuttal. Staff rebuttal, any rebuttals to any of the other presentations made?
This is Nicole Dixon. I think I'll start. I just wanted to mention that I think Mr. Ross made a lot of accusations and untrue claims against staff and our intent with these applications. One example is he said Mr. Eber was the only staff person that went out on site. That is not correct. I've been out there. Missy Lewick and Tyler Newman have been out there. Brian's been out there. My environmental planner and landscape associate have been out there. And we've all been out there multiple times trying to find a way to address this and work with them. Another claim that was untrue was that staff purposely did not have Brian on the call at the last meeting. That is not true. He was on the call and had to leave because he had another appointment after. We made sure that Brian's on the call today so he can answer any questions that are stormwater related. He made claims about Tyler not being an engineer, and Tyler was just relaying information that Brian asked him to relay. There's all these claims against staff, and I just wanted to kind of rebut that a little bit. Other than that, I don't really have anything to add other than Brian is on the call. So if you do have any stormwater questions, to please ask him to clarify anything that came up at the last meeting or today. And if you have any questions of staff based on Mr. Ross's presentation, please just let me know.
Okay. Thank you. Any questions of staff rebuttal? Mr. White, any questions?
No, ma'am.
Ms. Loudermilk, any questions of staff rebuttal?
No.
Mr. Walczak, any questions from staff?
None here.
Okay. And none for me. So now we move on to rebuttal by the applicants. We'll take them one by one. They have 5 minutes each, except for Mr. Ross, who has 2 properties, who would have 10 minutes. Ms. Barnum, do you have any rebuttal on behalf of Mr. DeVito, 117 Sandcastle Court?
I'm just simply going to reiterate the fact that we were all instructed not to present any new evidence because the reconsideration hearing was specifically for deciding whether or not it should be reconsidered, that we were merely to present that there were certain things that we feel were misunderstood or misrepresented in the original BZA hearing. So I do find it a little bit disturbing that the board doesn't even seem to understand specifically what this reconsideration hearing entails or what the rules are provided, because we were all given very detailed emails of what is and is not allowed. First off, the other thing I'd like to ask, just because it caught my attention and I don't see where it is relevant at all, but why does it seem as though every individual that has presented has been asked whether or not their home is for personal use or vacation rental use? Can I ask, from each of the board members, why that is of interest or lends anything to any of these hearings? What the home is being used for should not have any basis or anything. And if anything, coming from somebody who has been here since '94 and has been an active contributing member of this community, I personally feel after hearing that be asked by almost every board member of almost every applicant, that the responses from the applicants are creating a bias, and that the board members seem to have a aversion to individuals that are using their home for investment purposes.
No, ma'am, you may not ask that question of board members. You may only make your rebuttal.
Interesting. That's all I have to say then.
Okay.
Madam Chairman, can I clarify something here? Because I was the one that was misinterpreting the need for further evidence. That was my mistake. It was just said that she thought it was the entire board's opinion. Well, apparently it wasn't the entire board's opinion. It was my opinion. I thought we were here, so it was my mistake. I made the error, not the entire board. I made the mistake. I thought we were going to hear some new stuff. I was wrong. I apologize. But to depict it as if it were the entire board's fault is in error.
Okay. Thank you, sir. And I do recall that the board members have asked the town attorney several times questions about the standard for motions for reconsideration. So we have certainly been educated on this process. Mr. Ms. Grandin, you have 5 minutes rebuttal if you choose to make rebuttal.
Okay, I don't really have a rebuttal. First of all, I just want to thank you guys again for all your time. I know that you're volunteers and we've all been doing this for hours and hours. Obviously, you can tell this is a very important issue to all of us. And it seems like, people are getting pretty anxious and excited about it, and not necessarily in a positive way. We do appreciate your time and your understanding and the importance of this issue to all of us. And we hope that, I'm sure you're getting tired of hearing everything, but we hope that you do take the matter seriously as you have up to this point, and just realize that we all want to try to do what's best for the town and for our properties. And
Again, I think Rick summed it up well. We're talking about 24 to 36 inches. I mean, and that's really what it comes down to. And, I think that's why there are variance laws there, because there are times where it makes sense to do a variance. It shouldn't be, we have variance laws, we're not going to pass any, but we have to have them. I mean, this just seems to me, and again, obviously I'm biased, it just seems like a pretty clear-cut case as to why or when you might offer a variance. So again, thank you very much for your time.
And, when we did move into our house, once we got the approval and the CO, there was nothing in that backyard except for a pile of dirt. So we did try to do something to help the water flow and curb the flooding.
And at a big expense. I mean, I don't think, nobody on this north side went cheap. Everybody wanted it to look good, and they wanted to fix the problem and took it upon themselves, and we all thought we did the right thing. So
yeah,
now it's in your hands.
Right. Thank you very much for your time. We really do appreciate it.
Okay. Thank you, Ms. Grandin. Ms. Burke, it's your opportunity for rebuttal, and you also have 5 minutes.
Thank you very much. I appreciate the volunteer nature of all the work that you're doing and your perseverance and your consideration. So thank you from the bottom of our hearts in that regard. A couple of things that I think are important for you all to consider. I consider the variance process a remedy to a lot of things that have gone wrong, or that if we had to do it over again, we would do differently. Perhaps back in 2005, when the city allowed the berm, or the town allowed the berm, well, they don't do that anymore. So maybe the berm should go away. Well, maybe we shouldn't have allowed lots of 0.07 acres to be built. And then maybe we shouldn't have allowed our contractor to build houses that we think are too big, yet we granted that from the planning committee. Then we allowed a lot of other instances to take place. We took the town took the land adjacent to Sandcastles by the sea and then zoned it, I think, residential development or resort development. And now you're in the process of potentially fixing that and taking that back to what it should have been coded as originally, Parks and Rec. The objective of the remedy is to say, okay, how do we fix these events that have happened over a period of time that weren't intentional, but just happened over a period of time? So how do we get to fixing the water? How do we get to impacting the neighbors? And what's the big conclusion as a result of that? The interpretation of the 4 criteria is just that. The town obviously wants to enforce to the greatest rigor the standards that we have, that all of us want to keep Hilton Head beautiful, inhabitable, livable, return it to a natural vegetative state where appropriate. Laying sod and granting a certificate of occupancy is not returning to a vegetative state. None of us have impaired the airflow around the property on the northern boundary. All of that property is adjacent to town-owned land that actually is going to be impaired. It would probably be a worse impact if I dug the berm out and just let the dirt flow back into the town. I don't want to do that. I don't want to take out the retaining wall that's helping retain water and controlling the stormage, the storm drainage and those kinds of things. If you guys want to make me do an inspection every year so Brian will be happy with the pavers, happy to do that. Happy to plant more plants to over green the area around this. We'll do what we want to do. What we're really talking about is 24 to 36 inches wide and 10 to 15 feet long in terms of the square footage that's allowed. Well, you don't necessarily want us to go and replat everything because that's a kind of a ridiculous expense that will take years to do and all those kinds of things. So the variance becomes the remedy. The reconsideration for the hearing becomes the remedy, which is I think what we're trying to all get to here from how do we coexist peacefully and get the utility in what we want to get out of our properties, whether it's living down there a lot of time as we're doing now, or renting as a rental property. It's all the same in terms of trying to make for a good community. And that's really what I think the spirit and the tone of the variance process is supposed to be, is to get to an amicable agreement of what we can all live with. So I would urge you to consider that as the tone and tenor of our ask as we move forward, is that the reconsideration that we're asking for is to take a look at this in its entirety and then determine what's the best way to move forward for all of the residents of the island. Is it strict enforcement, or is it understanding that things change over a period of time and that we should move forward in the best possible outcome for the maximum number of people? And thank you very much for your time.
Okay, thank you, sir. The next applicant for rebuttal is Mr. Kazbov. You have 5 minutes as well, sir.
All right, thank you so much. Again, as everyone else has said so far, we do appreciate you guys taking the time to listen to us. And I know it's gotten a little tense at times during this meeting, but we're all here looking for the same thing, which is a resolution to a problem that makes sense for everybody. One thing I wanted to add that hasn't been said, of course, all of us on the northern boundary are in the same boat. We have all very similar arguments. Specifically, I wanted to add one thing. We've talked a lot about vicinity and how we want to define it. I've heard some board members want to define it as specifically our neighborhood. And if we were to do that, if we were to accept that as the vicinity, then we can still say that we are exceptional in that specifically the people on the northern boundary have this issue of the spoil pile that we're discussing and the water runoff. That is not an issue that other parts of our specific neighborhood have to deal with, especially on the interior. So if we want to be able to say this vicinity of just Sandcastle, what is exceptional about you? My answer to that would be this water runoff issues that is only being experienced by the northern side of the neighborhood. And with that, I'd like to say thank you for your time again, and that is all I have to add at this time.
Thank you, sir. Mr. Ross is the next applicant. Again, this is rebuttal time. This is not to plow over the same ground again. There are two lots and two properties involved, 121 and 127 Sandcastle Court. And you have up to 10 minutes. Again, rebuttal, not replowing the same ground. Thank you, sir. You may begin.
Okay, I just wanted to say that I just wanted to rebut what Nicole said earlier she said that she's working with us. And I have to fully disagree with that. She never told me that she came to my property. She never told me, do you want to meet there and so we can discuss something? The only reason that her and Tyler are out on my property is for one reason, enforcement. They're not there to try to help us or work with us because they have done nothing but try to enforce the letter of the law on this LMO and disregard every other circumstance on our properties. So to say that she's working with the homeowners is completely incorrect. And as proof of that, like I said earlier, this is coming down to 24 inches of patio pavers. And if Nicole and Tyler were actually, like they say, working with us, that can't possibly be true. No one's working with a homeowner over 24, going through all of these hearings, all of this cost, all of your time, over 24 inches of patio pavers. That's not working with us. So, that is not a correct statement that she's saying. And I just wanted to say that, I thank you for going through all this. I know it's a lot of work for you, as it is for everyone. And just a few hours of your deliberations, can in the long run save us a lifetime of headaches in our backyard. So we really do appreciate all your time and consideration in this matter. Thank you.
Okay, thank you, sir. Now an opportunity for board members for questions of any of the applicants about their rebuttal that I didn't ask before. Mr. Walczak, any questions of any of the applicants from their rebuttal?
No questions.
Okay, thank you, sir. Mr. White, any questions?
A rule of order, really. Can I ask staff a question?
Well, they had their opportunity for rebuttal. Is it related to their rebuttal, or is it related to the applicant's rebuttal?
Neither.
Okay.
I'll just jump in. You can tell me if I'm out of order.
Okay.
I mean, as we're, I guess, all talking about, we're trying to correct the past, or at least find a solution to past mistakes. And I'm directing it to Nicole. Nicole, if, today, would the town inspect the property, or in this particular case, like a stockpile, before they would give a CO?
In the last several years, we've tightened up our processes a little bit more, where we're reviewing buffers before construction and after, whereas maybe years ago that didn't happen. But I do want to clarify that this is not a stockpile. It's a berm that was designed and shown on the grading plans that were approved for the subdivision. So this isn't something that happened after the fact or a stockpile. It's a berm that was called out on their plans. And so when staff did do the CO, they would expect to find a berm out there.
Okay. And so it would have been on the CO.
Yes.
Okay. Thank you, Nicole.
You're welcome.
Okay. Ms. Loudermilk, any questions of you to the applicants based on the rebuttals?
No.
Okay. And I have no questions. So that concludes the process for the hearings on these motions for the petitions for reconsideration and whether or not a motion for reconsideration is appropriate. We will now go through, and Ms. Haley, I'll ask to make sure that all of the applicants' microphones are muted, and only the board members would have an opportunity to have a discussion at this point so that we can get rid of any background noise and can have discussion. If there's a staff member or if Mr. Coltrane, we need to ask them a question, then I think we would do that. But at this time, let's try to mute as many folks as possible. So the first application up for discussion and vote by the board is Variance 00-1976-2020. The address is 117 Sandcastles Court. The property owner is DeVito. The application was made and presented by Alexandra Barnum. Again, it is a motion for reconsideration. And as our rules require, the petition for reconsideration shall state with particularity the points alleged to have been overlooked or misinterpreted by the board. With regard to the process, a motion to grant the petition for reconsideration may only be made by a member of the board who voted on the prevailing side in the original vote. The effect of the granting of a motion for reconsideration shall be that the board will review the entire matter as if no previous vote had been taken. A motion to deny the petition for reconsideration may be made by any member of the board. The effect of a vote denying a petition for reconsideration is that the vote shall be considered to be the board's final action on the matter. A notice of action shall be delivered to the applicant following such vote. So the first thing I would ask board members, do you have any questions with regard to the procedure or the standard to apply in making this decision on each of those requests? Okay, hearing none, let's start a discussion on 117 Sandcastle, the DeVito property, application by Barnum. Let's go down through the list, and Ms. Haley has helped me out to try to do this on a rotating basis, so we'll try to keep doing that. Mr. Walczak, any discussion on that one?
Not at this time. I would like to talk about, you mentioned in making the motion, we need to describe, what was that again?
No, no, sir, that's the standard. The motion is either to grant the petition for reconsideration, or the motion is to deny it. Those are the two options. And the standard is that it's granted if the applicants have shown that the board overlooked or misinterpreted something that occurred during the first hearing of the matter.
So in other words, it's as simple as that. We don't have to go into the details of what was overlooked or whatever. Is that correct?
You do not, as I understand it, and Mr. Coltrane, correct me if I'm wrong in this analysis, but you do not have to state that, only to deny or to grant the reconsideration. If you want to discuss why you're doing it, that's okay, but the motion is either to grant or to deny.
Okay, thank you.
Mr. Coltrane, anything to add to that?
No, I mean, I think if anyone chooses to move to grant the petition, much like you do with the staff reports and things, you can suggest that the presentations made by whomever demonstrated the existence of some point that you think was overlooked, and adopt that as your reasoning. With respect to a motion to deny, I think it can be as simple as you find that the applicant failed to demonstrate any material point that was misapprehended or overlooked by the board. I mean, again, as the board members may choose based on their own view of what they've seen and heard today.
Okay, thank you, sir. Does that help out, Mr. Walczak?
Yes, it does. Thank you.
Okay, sure. Mr. White, any discussion or thoughts you have on the, again, 117 Sandcastle Court?
None at this time.
Ms. Loudermilk, any discussion from you?
I guess my thought or point of consideration is that the drainage/flood issue and the inclusion of the retaining wall within the original variance content, to me, I felt it was very confusing, or I'm struggling for the word here, but I think the whole issue of drainage, flooding, and the retainage walls and then apparently midstream, which none of us seem to grasp, all of a sudden, even though the retaining wall was included in the formal variance request, all of a sudden, apparently the retaining walls were taken off the table. I think the waters got a little muddied. So I can see valid reason to reconsider.
Okay, all right. So now to me, I have a different analysis of that with due respect, Ms. Loudermilk. I do believe we spent hours reviewing this. We asked a lot of questions at the previous hearing. I do not believe that we overlooked or misinterpreted or misunderstood or misapprehended anything. And we spent a good bit of time asking questions and exploring each individual applicant's, and especially with regard to 117 Sandcastle. I did not hear anything today to convince me otherwise. Then we proceeded appropriately, and I'm not inclined to approve the reconsideration request with regard to 117 Sandcastle Court. So with that said, I think it's time for me to ask for a motion by a board member. Because all of us remaining were on the prevailing side, any of us could make a motion. In this case, the motion to grant the petition for reconsideration has to be made by someone on the prevailing side. As the chair, the only way I can make a motion is to step aside as chair and have someone else to preside. So I will let you know that I'm not going to do that in this case. So that leaves it to the three of y'all if there's someone who wants to move to grant it. With regard to a motion to deny, anyone can make that motion to deny, and I would take the same position on that as I would on a motion to grant. So is there a board member who wishes to make a motion with regard to variance 00-1976-2020, 117 Sandcastle Court, the DeVito property?
Yes. I will make a motion to deny reconsideration of this particular matter.
Is there a second?
I'll second.
That's Mr. White.
I didn't get that. Could you try again?
I'm so sorry. I had my phone turned off, but Dash, as I call him, has decided I was talking to him. I apologize. Motion to deny by Mr. Walczak, seconded by Mr. White. Any discussion on the motion? If not, Ms. Haley, will you please call the roll?
Certainly. Mr. Walczak?
For the motion.
Mr. White?
For the motion.
Ms. Loudermilk?
Against the motion.
Ms. Bryson?
For the motion.
Motion carries 3-1.
So that reconsideration is denied. The next one is variance 00-1985-2020, 115 Sandcastle Court, the Grandin property. Let's start with Mr. White this time. Any discussion on this petition?
No.
Ms. Loudermilk?
No.
Mr. Walczak?
No.
And nothing from me. Again, the same standard applies, the same options apply. Is there a motion by a board member?
I can make a motion to deny this application for reconsideration.
That's Mr. Walczak made the motion. Is there a second?
Yes, I'll second that.
Mr. White made the second. Any discussion on the motion? Hearing none. Ms. Haley, will you please call the roll?
Mr. Walzak,
For the motion.
Mr. White,
For the motion.
Ms. Loudermilk,
Against the motion.
Ms. Bryson.
For the motion.
Motion to deny carries 3-1.
So that petition for reconsideration, the matter of variance 00-1985-2020, 115 Sandcastle Court is denied. The next one is variance 00-1874-2020, 125 Sandcastle Court, the Berks property. I'm going to make this a little bit shorter this time. Any discussion from any of the board members on this one?
No.
Okay. Hearing none, is there a motion?
I guess I will make the motion again to deny for reconsideration of this matter.
Okay. Is there a second?
I'll second.
Second by Mr. White. Any discussion on the motion? Hearing none, Ms. Haley, please call the roll.
Mr. Walzak,
For the motion.
Mr. White,
Mr. White?
Mr. White, if you could unmute on your end.
Yes, I'm sorry. For the motion.
Thank you. Ms. Loudermilk,
Against the motion.
Ms. Bryson.
For the motion.
Motion carries 3-1.
So the petition to reconsider in the matter of variance 00-1874-2020, 125 Sandcastle Court is denied. The next matter is variance 00-1935-2020, 105 Sandcastle Court. In this case, the only two board members who can make a motion to grant the petition for reconsideration would be Loudermilk or Bryson. But any board member can make a motion to deny. Is there any discussion by board members before a motion is made?
I'll make a
Hearing
motion.
none.
I'll make a motion to deny.
Mr. White made the motion to deny. Is there a second?
Charlie will second.
Mr. Walzak, second. Any discussion on the motion? Hearing none. Ms. Haley, will you please call the roll?
Mr. Walzak,
For the motion.
Mr. White,
For the motion.
Ms. Loudermilk,
Against the motion.
Ms. Bryson.
For the motion.
Motion to deny carries 3-1.
Okay. So the petition for reconsideration in the matter of variance 00-1935-2020, 105 Sandcastle Court is denied. The next one is variance 1853-2020, 121 Sandcastle Court. Is there any discussion on that matter? Hearing none, is there a motion? Again, any of the board members can make a motion. Either way.
I'll make a motion to deny.
Mr. White moves to deny. Is there a second?
Yeah, I'll second it.
Second by Mr. Walzak. Any discussion on the motion? Hearing none. Ms. Haley, will you call the roll?
Mr. Walzak,
For the motion.
Mr. White,
For the motion.
Ms. Loudermilk,
Against the motion.
Ms. Bryson.
For the motion.
Motion carries 3-1.
So the petition for reconsideration for variance 001853-2020, 121 Sandcastle Court is denied. The last of the matters is variance 001854-2020, 127 Sandcastle Court. Is there any discussion on this petition? Hearing none, is there a motion?
I'll move to deny.
Mr.
this
Wal-
application. Yep.
Mr. Walczak moves to deny. Is there a second?
I'll second.
Second by Mr. White. Any discussion on the motion? Hearing none, Ms. Haley, will you please call the roll?
Mr. Walczak,
For the motion.
Mr. White,
For the motion.
Ms. Loudermilk,
Against the motion.
Ms. Bryson.
For the motion.
Motion passes 3-1.
So the petition for reconsideration in the matter of variance 001854-2020 is denied. Thank you, board members, for those deliberations and careful consideration of those petitions. The next item on our agenda is board business. We have no business other than the hearing, a regular hearing is scheduled for January 25th. I would ask staff for our current count of the number of matters that would come before the board at the January 25th meeting. Ms. Lewick or Ms. Dixon, can you tell us how many matters are remaining for us to consider at the January 25th meeting?
This is Missy Lewick. I would have to double check. I'm pretty sure we have 3 cases in January, but I can get back to you on that.
Okay. Board members, the reason I was asking that is whether or not we need to have an earlier start for our meeting, and we did not know what action would be taken on the petitions for reconsideration. So it sounds as though the one meeting in January will suffice, we will remain at the 2:30, the regularly scheduled time, unless we need to call a special meeting.
Madam Chairman,
Yes, sir.
I have a question. I presume we're going to continue with virtual meetings, but I would really like to know if any of the town people have any indication as to when we might get back to normal.
Ms. Lewick, Ms. Dixon, Mr. Newman, anybody else from the town?
I think, sorry, this is Nicole. I think we were anticipating, in the new year trying to get back to in-person meetings, but because of the rise in cases, I think that has been pushed off a little bit. So I think right now we'll probably wait till after the holidays and reassess.
Okay, thanks. Thanks, Nicole.
Meanwhile, we'll keep struggling through. So far, we're behaving pretty well, and great thanks to the staff for helping us with technical challenges, and thanks to the public members who have participated in the meetings and presenting in a way that the board can understand. We appreciate that very much. The next item on the agenda is staff report. We have 3 items. The first is an update on the 2020 LMO amendments recommended by the BZA. We had prepared and asked the chair to prepare some requests to be considered, and I've asked the staff to include this on the agenda so we keep updated with regard to our requests. So, Ms. Dixon, I understand you're going to respond to that matter?
Yes, ma'am. I just wanted to let y'all know that because of the COVID pandemic, our typical 2020 amendment list that we were planning on taking forward got pushed off, and council decided to entertain a little bit of higher priority amendments that had to take place throughout the year. So what we're looking at is now a 2021 set of amendments. So everything that was on our list will start doing research and moving forward with hopefully at the beginning of the new year. So we have not forgotten about your recommendations. They're still on the list and will be taken forward at a later date. And then the second item on your agenda regarding the waivers, staff did look into the waiver list to see if there were any potential LMO changes that we thought should be taken forward because of the amount of waiver requests. And we didn't find anything wrong with the LMO. And I want to kind of go back to the reasoning why we have the waivers to begin with. So back probably around the...
I'm sorry to interrupt you. I think it's going to be very helpful for us to hear that, but I think it would be very helpful for the rest of the board members who couldn't be here today to hear that as well. Especially due to the late hour, does the board have any objection to us putting off that report to the January board meeting?
No, that's a good idea.
Okay. Thank you. Thank you, Ms. Dixon. We do appreciate your being prepared to address that today, but hold those thoughts.
Okay.
Okay, great. All right, and then the last staff report I think we have is the waiver report from Ms. Lewick, and the board was furnished with a written report. Ms. Lewick, it's up to you now.
There have been 2 waivers that were granted since our last meeting, and they're outlined in the report. They're both in association with redevelopment projects. If you have any questions, I'd be happy to answer them.
Any board member, I'm not going to go down the roll again. Any board member have any questions with regard to the waiver report?
No.
Okay, hearing no questions. Anything else to come before the board at today's meeting?
I just have one thing. I misspoke on the number of cases coming up for January, and I forgot about the 2 reconsiderations that were coming. So we actually have 5 variances and 1 appeal. 4 of the variances are in Sandcastle, 1 is at another location, and then we have an appeal. So we may be inquiring with board members on establishing 2 meetings in January because that would be a really long meeting.
Okay, so we'll keep our regular meeting on January 25th at 2:30 and then look to see about another January meeting date, which would be a special meeting. Is that what you're recommending?
Yes, that's correct. We've identified 3 dates in late January that work for meeting room availability and IT scheduling. And so once we have identified if those 3 dates work for board members, then we'll kind of go from there. But we do have some additional dates that we've identified.
Okay, and we don't need to establish that other meeting date today. We can wait and call a special meeting. Is that correct?
Yes.
Okay, all right. So any questions of board members about January meetings? Okay.
No.
If not, anything else from the staff? Anything else from the board members?
Have a great holiday, everybody.
The same to everyone,
Absolutely.
including members of the public who are listening and the staff. And I will declare the meeting adjourned at 5:59 p.m. Thank you all very much. Be safe.
You be safe. Yes.
Thank you.